Hey, you guys, how are you? So, I thought today would be a slow day while we wait for the response from the state to the motions to recuse. Yesterday, we saw Adrian Love ask for a 48-hour extension to respond, which was granted by Judge Rachel Krause. So, in the interim, last night at 8:30 p.m., we have this huge whopping supplement filed by Brian Steele and Keith Adams to supplement the motion to recuse Judge Glanville. And you guys in the chat are already noticing it. It's full of a ton of footnotes. We've got some email exhibits. We've got some initial correspondence between Melnick and the attorneys. It's got a lot of stuff in it. So we're going to go through it, you guys. We are going to get right into it. And I saw a comment from Heart of Inspiration. What do you guys think? So Heart of Inspiration said, this should be real good. Maybe the state shouldn't have asked for 48 more hours to respond. Give Steele and Company 48 more hours to give you 48 more reasons to recuse. So what do you guys think about that? Because I kind of agree. I wonder if they wish they had just filed yesterday. But let's get into it. Let me make this bigger for you guys. I am having issues. My windows don't want to resize the right way. I don't know why. But who knows? It's like it's only letting me expand the window in one measly direction. So I think that'll work for us right there. And again, this was filed last night at 8:30 p.m. So supplement to motion to recuse Judge Glanville. And we've got 3 footnotes in the title of the motion. So this is half the page. Half the page is footnotes. So footnote 1 says, this motion applies to lawyers Love and Hylton in addition to Judge Glanville, as all 3 are material witnesses in the case at bar, and all will be called by Mr. Williams during trial to show judicial and prosecutorial misconduct. Now, this is a footnote to the title of the document. If you're a material witness, you've got to step back from the case. And here, it's clear, I'm sure this isn't really that surprising, but it's clear in the very first footnote to the title that Brian Steele is going after not just judicial, but also prosecutorial misconduct. Which means, if prosecutorial misconduct is the reason a mistrial is declared, double jeopardy could apply and there will be no retrial for these defendants. It's beyond my scope to understand what this would mean for the defendants that aren't enjoined in this case, this instant case. But who knows? I'm sure they'll make some arguments there. Footnote 2, because again, we've got 3 footnotes to this title. That's crazy. This motion also timely moves to recuse the Honorable Judge Krause, based upon the fact that she sits on the Fulton County Superior Court bench with Judge Glanville, and that in April of this year, Judge Glanville contributed $2,000 to the Honorable Judge Krause's reelection campaign. Also in April 2024, the Honorable Judge Krause donated $500 to Judge Glanville's reelection campaign. Mr. Williams' trial has been ongoing since January 4th, 2023, and therefore includes this time frame. So they're citing some case law here where I'm assuming this case law says that stuff like this could be a conflict. So this judge shouldn't be hearing these matters. And then 3, undersigned counsel derives no happiness while filing the supplemental motion. However, let justice be done through the heavens fall. Actually, the heavens will not fall by unmasking biased and unethical members of the bar. What? Did they just put an afterthought in this footnote? They literally said, well, hold on, actually, we're fine. If you actually follow the arguments in this motion we're about to make, listen to us and give us the relief that we're going to request, the heavens actually will not fall. You'll save the heavens from falling. That's a crazy footnote. So we'll go back up to the top half of this paragraph, of this page. Comes now Mr. Jeffrey Williams, by and through undersigned counsel, and hereby timely files a supplemental motion to recuse Judge Glanville in the above referenced case. In support of this motion, Mr. Williams shows as follows. Guys, since it's so long, we probably will skip some of the case law, but we're going to get to a new joint affidavit from Steele and Adams and some of the exhibits that are attached, because it's really interesting stuff in here. This supplement to motion to recuse Judge Glanville, as well as the attached joint affidavit, is timely based on Rule 25.1 and whatever. So we're in the time frame. All right. So the Honorable Supreme Court of Georgia has taught. So we're citing the Supreme Court. The law of our land has taught that a motion to recuse is timely under 25(1) if it's filed within 5 days after the affiant first learned of the alleged grounds for disqualification, excluding Saturdays and Sundays. So they're probably going to say the release of this transcript is that triggering time. Thus, the supplement to motion to recuse is timely filed, as the additional reasons for this recusal were first learned on Monday, July 1st, 2024, when Judge Glanville permitted the court reporter to release the undersigned counsel of the transcript of the Monday, June 10th, 2024 ex parte meeting. I think put a 1 in the chat if you guys have looked at that transcript. Put a 2 if you haven't seen the transcript or what was really contained in it, because I'll probably skip re-summarizing anything about that meeting. We'll get some more context in this motion. But if you guys are completely lost on that transcript, put a 2 in the chat. If you're good on the transcript, you know what it was, put a 1. So lawyers Hylton and Love, Judge Glanville, the Honorable Attorney Bumpus. So yes, we get an honorable for Bumpus, but we don't get an honorable for Judge Glanville, lawyers Hylton or Love. You guys see that? So the honorable is only mentioned for Attorney Kayla Bumpus and her client, sworn witness Mr. Kenneth Copeland, and others. And we're going to look at that affidavit. This timely filed supplement to motion to recuse has also been timely presented to the Honorable Judge Krause and Judge Glanville on Monday, July 8th. And in the case at bar, so this case, Judge Glanville's ex parte communications with the sworn witness, his counsel, lawyers Love and Hylton, and other representatives with the Fulton County District Attorney's Office are seemingly only partially captured by the court reporter. So they attach the transcript. Judge Glanville, lawyer Love, and lawyer Hylton have prejudiced and tainted Mr. Williams' trial so deeply as Judge Glanville has not acted as a judge, but morphed into, someone put him on an Animorphs cover, an essential part of the prosecution team. Oh my God, someone please make an Animorphs cover of Judge Glanville turning into Adrian Love. The judge's conduct, including ex parte communication with the prosecutor during trial, resulted in the appearance of bias, requiring reversal of the convictions and sentences. So they're going to cite here that USCR 4.1 mandates that judges shall neither initiate nor consider ex parte communications. And we've looked at this, right? We've seen this Rule 4.1 a bunch of times. When is an ex parte communication acceptable? What should a judge do if they need to have an ex parte communication for a valid reason? They got to promptly notify the other parties. So we've seen a lot about that. But Judge Glanville participated in these ex parte communications and then somehow attempted to keep the secret by referring to the meeting as privileged and describing the improper secrecy as sacrosanct. And I'm sure this is going to be a YouTube link in the footnote, maybe. Oh no, they're defining what sacrosanct means. Most sacred or holy, inviolable, immune from criticism. Steele and Adams are funny. Judge Glanville has totally abandoned his role as a judge and has become a prosecutor against Mr. Williams. Ex parte communications are presumed to be harmful error, and any conviction and sentence will be reversed unless the state proves the error was harmless. So the burden, according to City of Pendergrass v. Skelton, the burden is on the state here to prove that this violation, this ex parte communication violation, it's the state's burden to prove it was harmless, not the defense's to prove that it caused harm. Mr. Williams timely raised his objections to these ex parte communications and recusal of Judge Glanville, to wit, when he first learned of same. And we saw that play out if you guys were paying attention to that Monday morning on June 10th. Brian Steele has an inquiry for the court. He goes up to the podium and then all hell seems to break loose. So Canon 2, Rule 2.9 of the Georgia Code of Judicial Conduct forbids a judge from considering ex parte communications, as judges shall accord to every person who has a legal interest in a proceeding or that person's lawyer the right to be heard according to law. Judge Glanville embraced his view that the communications at this ex parte hearing were, quote, privileged. And then he's attaching the record from those days, those transcripts. He's got it included in multiple exhibits here. So I'm assuming that some of these are going to be transcripts from oral arguments in court. But we'll see. And then we get to look at the order of contempt and incarceration for Brian Steele. Judges shall not initiate, permit, or consider ex parte communications or consider other communications made to them outside the presence of the parties or their lawyers concerning a pending or impending proceeding, except communications for administrative purposes, emergencies, consultations with experts or court personnel, and settlement conferences. And then they also say that Rule 29 is clear that communications are presumed by default, inherently, to have been in error. And once a party has shown that a judge has received an ex parte communication, there's a presumption of harm that can be overcome only by an affirmative showing that the judge did not consider this communication. So the burden is not on the defense to prove that this caused harm. The presumption is there, and there has to be an affirmative showing from the judge that this was not a violation, this didn't cause harm. And they cite several cases here. So we're getting Hargis v. State and State v. Hargis, and then Arno versus Arno. In the case at bar, there is not a scintilla of evidence. That's a fun word. To overcome the presumption that these impermissible, illegal, and unethical ex parte communications, as captured in attached Exhibit B, resulted in harm. So in other words, and this comes back to you guys in the chat who've looked at this transcript and have looked at June 7th, right? I'm sure we're going to hear about June 7th. June 7th was the Friday before the Monday ex parte meeting. If you watch the hearing from that day, you can hear in court Love and Judge Glanville talking about the reason they need to meet Monday morning. And the reason they need to meet Monday morning doesn't involve an issue of safety or something privileged, because they're talking about it in open court on June 7th. So they can't retroactively, the following week when they're called out about it, say, there was a reason that this was actually privileged. And then we get the transcript, we look at the transcript, and you guys in the chat that have gone through that transcript, is there anything in that transcript that overcomes the presumption that these unethical ex parte communications were somehow okay and didn't result in harm? So thus, Mr. Williams' case should be reversed on direct appeal. So right now, take it right to the appeals court if there's any conviction and sentence. So they're comparing to another case. And I don't want to read too much case law about ex parte because we've kind of beat that with a hammer. I think we get that for the most part. But we're going to get to this joint affidavit, which is going to supplement. We're going to see more reasons asserted by Brian Steele and Keith Adams why Judge Glanville not only conducted this improper and unethical ex parte meeting, but that Judge Glanville acted as an advocate for the Fulton County District Attorney's Office as he dispensed legal advice and supported lawyers Hylton and Love's goal to have Mr. Copeland testify against Mr. Williams and the other co-indictees. In light of this ex parte proceeding, it is impossible to conclude that Judge Glanville is impartial and not a member of the prosecution team. Now, this argument right here, do you think, I personally, that's kind of where I stand. It seems like Judge Glanville is on the side of the prosecution team and that he's not impartial. Do you agree with that? Put a 1 if you agree with that. Put a 2 if you're not sure. Put a 3 if you think he's in the middle and just stuck in a bad situation. Because me personally, I'm a 1. So judges shall disqualify themselves in any proceeding in which their impartiality might reasonably be questioned, including cases in which the judge has a personal bias or prejudice concerning a party or a party's lawyer, or personal knowledge of disputed evidentiary facts concerning the proceedings. So we're getting that same Rule 211. Judge Glanville has been derelict. Oh, the word choices are funny. Judge Glanville has been derelict in his judicial duties and must be recused. Once evidence of this illegal ex parte Star Chamber meeting was revealed by undersigned counsel in the afternoon of June 10th in open court, lawyers Hylton and Love sat mute, while Judge Glanville found undersigned counsel in contempt of court and sentenced undersigned counsel to the longest possible time in jail for unmasking Judge Glanville's, lawyer Love's, and lawyer Hylton's improper, illegal, and unethical conduct. They are throwing all the adjectives. And then let's see. Oh, so the footnote here. In addition to violations of Georgia rules of professional responsibility, which could carry penalties up to disbarment, felony crimes such as violation of oath of office as codified in OCGA. This is that's what this footnote is. Judge Glanville must be recused from any further action on Mr. Williams' case. Let's see. These reference sections are meant to be self-enforcing, as it's the judge's duty to disqualify himself as soon as he is aware that the grounds exist. They're going to cite some case law here. In the case at hand, the state cannot show that Judge Glanville's lawyer Loves and lawyer Hylton. Guys, I love that they keep saying the judge and the two lawyers. This criticism, we want Judge Glanville to recuse. Like, this motion to recuse is still focused on Judge Glanville. But this is a big hint. We're only on page 6, and Love and Hylton have been attached to this argument multiple times already. So do you think something's coming in the future where he's going to want, where Steele and Adams are going to ask Love and Hylton to recuse? Not just because they've made themselves witnesses to all of this, but also because of the misconduct. So I wouldn't be surprised if we get another motion. It will repeat a lot of these arguments, but it will be specifically tailored to Love and Hylton. They're not letting up on the pressure. So they're calling the three of their behavior intentional and willful complicity in these ex parte communications, and there's no way they cannot show that that was harmless error. As shown in Exhibit B, which we'll look at, the improper influence and interjections by Judge Glanville and his two cohorts. So now they're cohorts. Yo, the verbiage in this is great. From the Fulton County District Attorney's Office on Mr. Copeland, change Mr. Copeland's stance not to testify against Mr. Williams. So they're citing the transcript here, it looks like. If Mr. Copeland refused to testify, all of his prior false, inculpatory statements as to Mr. Williams would not have come into evidence. So talking about those interviews, those police interviews, they wouldn't have been able to come in. And we know that, because Hylton, I think it was Hylton that said it on June 7th in open court. Well, can you call other witnesses while we figure out this thing with Kenneth Copeland? No, Your Honor, because we need Copeland to lay the foundation for the videos we need for the witnesses that are after him. So we need to call Copeland first because we need to get this stuff in. So Hylton painted the A to Z of what and why they needed Copeland, not just to sit on the stand, but to testify to what they needed him to testify to. They needed him to lay the foundation to these other things. So without all of this, without this ex parte meeting, the foundation for these police interviews wouldn't have been laid. So you see, it's like a stack of dominoes. So let's see. And this is a problem because it's problematic for Mr. Williams' constitutional right to confrontation, because they weren't allowed to be present during this ex parte meeting. Intimidations tactics thrust upon Mr. Copeland by the combined work of Judge Glanville, lawyer, I'm sure they're going to say Hylton Love. We got a typo here, guys. I think that's our first typo. Love and lawyer Hylton resulted in Mr. Copeland's decision to testify, and thus Mr. Williams has another witness to challenge a trial. Can you imagine Brian Steele, and honestly, like Max Sharp too, being able to put Glanville on the stand, put Love on the stand, put Hylton on the stand? Can you imagine Adrian Love in the witness booth? That would be, we'll watch that live if that happens. Moreover, ex parte communications are so disfavored and repugnant that even if the ex parte communication would be cumulative of other evidence introduced at trial, same would not be harmless error because the ex parte communications are presumed to be reversible error. So Mr. Williams' fundamental constitutional rights were trampled, ignored, and violated as a result of Judge Glanville's lawyer Love's, and lawyer Hylton's improper, unethical ex parte meeting with witness Copeland. Moreover, the cover-up, secrecy, and silence of these three team members is unforgivable. To wit, after the Star Chamber meeting, the three public officials, is in quotes, simply strolled into the courtroom, faced the cameras, called for the jury, and feigned to continue trial as if nothing out of the ordinary occurred just hours/minutes before. And then they timestamped the clip. They timestamped them entering the court on Monday, June 10th, after this ex parte meeting. They said, here's a citation for them simply strolling on in. And maybe we can come back and watch that. This is a long document, guys. So If you guys do want to replay that, I've done recaps of just that moment of court. And then, obviously you can look up June 10th. But if we have time, we can come back and look at these clips and watch the body language. Mr. Williams needs to examine Judge Glanville, lawyer Hylton, lawyer Love, and all other members of their prosecution team to reveal the date and time of every ex parte communication that occurred concerning Mr. Williams' case. Every ex parte communication. So they're not even saying, hey, we want to know if there was more. This is a presumption here. Steele and Adams are saying, we want to know about these other ex parte communications you've had. We're not saying if you've had them. We're just saying we want to examine you on them. Any other ex parte communication that occurred concerning Mr. Williams' case since its inception. The subject of same and order the court reporter to produce any transcript of same and or unseal all documents from these potential improper ex parte communications. Undersigned counsel needs to cross-examine all of these parties. And they gave me an enter here. They gave me a long line. I can take a breath, drink some water. And thank you guys in the chat. I'm not trying to not see comments. This is just a long document. So we'll front load it. At the end of the video, we'll chop it up. But please keep having conversations in the chat. You guys are great company. Just don't take it personal. I'm not hopping over there and looking at anything at this moment. Oh, and another sentence. So undersigned counsel needs to cross-examine all of these parties to ensure that the sworn testimony is spread in open court and on the record. Now, do we have a footnote that's important here? So undersigned counsel objects to any proffer by Judge Glanville, lawyers Love, and Hylton. Other objections to proffers will be made at the time of the attempted proffer. So guys, remember a proffer is, you're basically offering something onto the record. You've seen Sharp do this a lot. You've seen Steele do this a lot. You've seen the attorneys do it here and there. But essentially, I don't want to hear your argument or I'm denying it. Well, can I offer this up for the record? That's what they mean by a proffer. And they're saying here, we object to Judge Glanville, Love, or Hylton having the opportunity to go and argue something into the record right now at this moment. And we'll continue to object if they make any further attempts in the future to proffer something on their own behalf. So interesting footnote. Mr. Williams' trial is constitutionally broken based upon the unconscionable misconduct of Judge Glanville, Love, and Hylton, all working together in an effort to convict Mr. Williams. Which again, this is not, the tribunal absolutely should not be working in an effort to convict. And Love and Hylton, the prosecution, the state, the government, their goal should not be to convict by any means necessary. Their goal should be to convict if the conviction can be justified and proven beyond the reasonable doubt standard. The goal should never just be to convict for the sake of conviction. And here, Steele and Adams are saying all three are working together in the effort to convict. The criminal justice system in Fulton County, in the state of Georgia, and in America has been attacked by the conduct of these three actors. This injustice must end immediately, beginning with Judge Glanville removed and disqualified from Mr. Williams' case. Thereafter, this motion is also timely made for lawyer Love and lawyer Hylton to be removed and disqualified from Mr. Williams' trial. And the Fulton County District Attorney's Office must be investigated for their improper conduct, if any. So we get a little qualifier there, if any, outside of the actions of lawyer Love and lawyer Hylton. So here it's being stated, we also need this action against Love and Hylton, and maybe a further investigation to see if we should take further action more broadly with the District Attorney's Office. Judges must scrupulously avoid improper ex parte communications, whether or not they consider them. A judge has the ethical duty to recuse himself sua sponte, so without even being asked. Sua sponte means my own decision. If I'm the judge, I'm going to make the decision on my own without needing to wait for someone to raise the argument to me. I know the rules. I'm not supposed to hear a motion about myself or something I could be biased about, something I could be a witness to. So I'm just going to step down, pass it on over. Sua sponte. So, but we know Judge Glanville didn't do that. And here they're going to argue Glanville did the opposite of recusing himself sua sponte, even though he's keenly aware that helping lawyer Love and lawyer Hylton to influence Mr. Copeland to change his mind and testify against Mr. Williams is not permitted by any judge in any court. Instead, Judge Glanville, the chief judge in the Superior Court of Fulton County, Georgia, has taken upon himself, at the behest and encouragement of lawyers Love and Hylton, to ally himself with the prosecutors in this case. Judge Glanville's misconduct shall not stand, and the law must be followed. Judge Glanville must be recused and disqualified from Mr. Williams' case instanter. So now, no hearing is actually needed to reach the finding that recusal of Judge Glanville is mandated. So yeah, it should just be known. Judge Glanville has automatically caused his recusal and disqualification from Mr. Williams' case by unlawfully becoming actively involved when he presented argument refuting affiant's allegations of judicial bias. And then they're going to cite, we got a YouTube timestamp. It looks like a 12-minute, 13-minute argument. If this honorable court disagrees, Mr. Williams respectfully requests a hearing, as he will call Judge Glanville, Love, and Hylton as witnesses to fully unmask this above discussed misconduct, as well as further misconduct that may have occurred. This judicial and prosecutorial misconduct. So here we go again. We're making sure Steele and Adams, it's all three of them. Even though this motion at issue right here and right now really deals with Glanville's recusal, you can't detach the misconduct because it's in concert. It's together. They're all doing it together. So this judicial and prosecutorial misconduct denotes a disgraceful episode in Fulton County courts, the Fulton County District Attorney's Office, and it stains the court throughout the state of Georgia and our country. What occurred in this Star Chamber, outside the view of cameras, in the shadows, and hidden from Mr. Williams and his counsel and the public, is unpardonable, and all in violation of Mr. Williams' constitutional rights stated herein as well as in Exhibit A. Judge Glanville, Love, Hylton have created secret Star Chambers proceedings, which the state of Georgia has promised its citizens it would never engage. As the Honorable Supreme Court of Georgia has taught, justice faces its greatest threat when courts dispense it secretly. Our system abhors Star Chamber proceedings with good reason. And then they cite, this is actually a case with Atlanta Journal and Atlanta Constitution v. Long. So, Glanville, Lawyer Love, and Lawyer Hylton have teamed up to conduct their illegal and unethical conduct outside the view of Mr. Williams and his counsel, the public, and outside the lens of the cameras. Now, this might seem like a similar issue to, they had an ex parte communication violation. There is an overlap here, but it's a separate issue that things are being withheld from the record, being withheld from public access. So it's an overlapping issue, but it's a standalone issue at the same time. These, quote, public officials shall never be trusted by Mr. Williams or undersigned counsel. There are serious consequences for those intentional and unjustified misdeeds that have not yet been dispensed. The clear evidence is that Glanville is not impartial, and or there is at least the appearance that Judge Glanville is not impartial. You guys can debate in the chat. Is it clear? Is it actual impartiality, or is it just an appearance? Is it actual, or is it an appearance? Judge Glanville must be removed, disqualified from Mr. Williams' case. And then let's see. We're going to get to this affidavit. This is going to be, I think, one of the most interesting parts of this document, that and some of the communications involving Melnick, which are attached as other exhibits, but as sworn to in Exhibit A. Because remember, these affidavits, when you're making a motion, that's an argument. But the things that you're arguing aren't necessarily facts. You have to provide the facts. And a way that you can do that is by submitting a sworn affidavit. So that's why we have to have this affidavit to supplement the arguments that we're seeing so far. So we're going to look at that affidavit. It's got a lot in it. It's much longer than the initial one that had, I think, 14 to 16 bullet points, line item numbers. This one has like over 30, I think. So it's sworn to in this new affidavit from Adams and Steele. Glanville, Love, and Hylton conspired to conceal and suppress Brady material, Brady evidence. This Star Chamber cannot prohibit Brady, and we're getting an underline here, evidence from coming forward. That is exactly what Judge Glanville, Lawyer Love, and Lawyer Hylton planned to do. Mr. Williams' constitutional right to due process, a fair tribunal, a fair trial, effective assistance of counsel, right to cross-examination, right to see, hear, and be present for the statements of a sworn witness have been obliterated by Judge Glanville and his cohorts. Judge Glanville must be removed as he has forfeited his position as judge. Now, this is actually, so they're kind of bullet pointing all these things that could be appeal issues, argued on appeal. But I also appreciate that they include effective assistance of counsel, because I like to look at appeals and sometimes one of the key arguments that I see appeals courts actually say, you know what, that is harmful, is ineffective assistance of counsel. And here, Steele and Adams aren't saying we suck at our jobs because we just suck at our jobs. They're saying we were prevented, because we were kept out of this meeting, we were prevented from providing effective counsel to our client. So sometimes lawyers will throw themselves under the bus on appeal and be like, I sucked, I did a bad job, I had too much workload, I'm a public defender trying to work 2 capital murder trials. So I just wasn't I didn't call the witnesses I should have, I didn't do a good job. And sometimes the appeals court will agree and send the trial back down to be retried. So here, I think it's very important that they're including this. They're not taking shots at themselves, but they're saying we were prevented. We didn't have what we should have had in front of us. We didn't have the opportunity to provide effective counsel. So that's all these little arguments that you'll see raised on appeal if it goes to that level. This is really a good one. It's one that I see appeals courts kind of say, yeah, that's a problem. The June 10th, 2024 Star Chamber meeting between Judge Glanville and lawyers Love and Hylton undermined the public's faith in the integrity of the justice system as it conceals from the public, Mr. Williams, his lawyers, and the others facing the removal of their liberty, critical information about the lawfulness and reality of how they are being prosecuted. This injustice must end today. This trial is wholly broken and cannot ever be repaired based solely upon the improper conduct of Judge Glanville, lawyer Love, and lawyer Hylton. Any motion for mistrial made by Mr. Williams is based exclusively upon the improper actions of a supposed judge and state actors. Now, this is important again, because this comes down to misconduct. So these motions for mistrial, the underlying argument is misconduct, which would bar retrial. You know, a lot of mistrials usually end up, the prosecution could say, hey, we do want to retry. We have the opportunity to decide that we want to retry. But if there's a mistrial because Love and Hylton messed up, they don't get that opportunity to retry. Judge Glanville, at the indecorous Star Chamber ex parte meeting, provided legal advice and direction to Attorney Bumpus about how to speak with her client, Mr. Copeland. Dispensing legal advice creates a clear appearance of partiality, which is a proper ground for the granting of this motion to recuse under a code of judicial conduct and a constitutional violation of due process. Mr. Williams' constitutional right to due process has been violated because not only is there an appearance of partiality, but there's actual bias, as Judge Glanville has been embroiled in this trial and is assisting the prosecution to attempt to gain a conviction of Mr. Williams. Because again, his participation in this meeting is creating a domino effect for evidence admissibility. It is impossible for any reasonable person to believe that Judge Glanville is neutral. Judge Glanville must be removed based upon the one ex parte communication that has come to light thus far. So where are the rest? Judge Glanville, lawyers Love and Hylton have infected the process of Mr. Williams' trial and have illegally poisoned the same forever. Judge Glanville had the ethical duty to recuse himself sua sponte once he had these ex parte communications. However, neither Judge Glanville, lawyer Love, nor lawyer Hylton uttered a word that they spent the morning of June 10th leaning on Mr. Copeland to testify for the prosecution against Mr. Williams, and 2, coaching Attorney Bumpus on what and how to sell to Mr. Copeland the proposition to cause him to testify at trial against Mr. Williams, and 3, coaching Mr. Copeland on how to deliver his testimony, and 4, promising Mr. Copeland that he would not be prosecuted even for perjured testimony unless he told, quote, a bold-faced whopper. God, that transcript, man. These public officials, and I love that this is in quotes every single time, because who are they serving? And remember, guys, that immunity deal, the DA, Fani Willis, signed off on that in the interest of the public. That was the reason that they said it rose to the level of signing off on that immunity deal for Kenneth Copeland, for Woody. It was in the public interest. These public officials working in the public interest. These public officials heard and failed to reveal that Mr. Copeland confessed to committing every indicted offense in this case. I did these crimes. Even non-lawyers can see, they're talking about us, you guys. Even non-lawyers can see that Judge Glanville Lawyer Love, and Lawyer Hylton. Shout out to you guys in the chat. Say chat in the chat. This is a shout out to us on YouTube, looking at this case and asking what the heck is going on. Us non-lawyers can see that Glanville, Love, and Hylton are not acting in an ethical manner, are on the same prosecutorial team, and that Judge Glanville should not be rewarded with the opportunity to continue to preside as judge over Mr. Williams' jury trial. In reality, Judge Glanville, Lawyer Love, and Lawyer Hylton have made themselves witnesses who Mr. Williams' counsel will call. These three lawyers must be recused and removed from the case. Now let's check this footnote here. Mr. Williams' counsel has announced in open court, so that he will call these three offenders at trial. Offenders? Judge Glanville's Lawyer Love's and Lawyer Hylton's names appear on Mr. Williams' filed 8 amended list of witnesses. That's hilarious. They're offenders now. They're lumping them right in with the people they're trying to prosecute. Call them the same names they call the people they deal with. Dehumanize them. Dehumanize them like the state does to defendants and to witnesses that they give plea deals to. It is important to note that Judge Glanville originally denied Mr. Williams' request for access to the June 10th, 2024 ex parte hearing transcript, keeping contents of the record totally hidden by Lawyer Love, Lawyer Hylton, and Judge Glanville. Fortunately, mounting pressure related to Judge Glanville's gross misconduct, violation of his oath of office, ethical violations, and potential criminal conduct by Lawyer Love, Lawyer Hylton, and Judge Glanville work to effect change. So again, shout out to everyone who applied the pressure. On Monday, June 17th, 2024, Judge Glanville denied undersigned counsel's motion to recuse and went forward with the trial of this case. Similarly, Judge Glanville denied the Honorable Douglas Weinstein's motion to recuse on June 12th. Judge Glanville then continued to unlawfully preside over Mr. Williams' jury trial. Now, what were they doing during that time period? They were looking at, well, they started to have Woody testify about some of the police interview footage, because they're like, well, we don't need to go through that much of it. We can just start playing that one today. And then for the rest of the week, while the jury's not here, we're going to look through the rest of the footage and you guys can make your argument about what should come in, what shouldn't come in, whatever. So, like, that's weird because we found out from Shart that they didn't prep Woody as they normally should and would with a witness. Hey, this is the stuff we're going to show you. We want to talk about your testimony. You're going to be on the stand. We're going to ask you about these things. We're going to show you these video files from these days. They don't prep Woody with that stuff, which is unusual, which is weird. And they also didn't determine ahead of time what parts of these very long videos they wanted to bring in. They do all that after they get a surety, they get assurance. And I don't even want to say get assurance. They kind of forced the assurance because the immunity deal was just given to Woody. It's not like he said, I want that and I'll take that and I'll testify if I get that. It's just something that was given to him, which removed, his privilege, his right to assert the Fifth Amendment. They wait to do all of these arguments about these videos until they make sure that they've locked in Woody's testimony. Normally, some of that stuff would at least be hashed out before the witness gets on the stand. Like, think about how weird this whole roadmap is. It's poor strategy, if you ask me, but it's also shady. But let's keep going before I go on to a rant for too long. So Glanville ends up unlawfully presiding over Mr. Williams' jury trial, and Glanville must be removed as he's proven to have actual bias as well as the appearance of bias. So undersigned counsel has never been afforded the questions that Lawyer Hylton and or Lawyer Love created and gave to Mr. Copeland. Undersigned counsel has never been given this list of questions, even though Judge Glanville has been made aware of these questions and has encouraged Attorney Bumpus and Mr. Copeland to review and understand these questions. So they're going to reference the transcript again. The question must be asked why Judge Glanville has ex parte access to Lawyer Hylton and or Lawyer Love's questions for a witness. This conduct is beyond repair. And remember, a judge is supposed to kind of stay away from learning anything that may not yet be on the record. The judge is supposed to stay out of that. Judge Glanville, Lawyer Hylton, and Lawyer Love did not give a hint that they were meeting ex parte with witness Copeland on the morning of Monday, June 10th, or at any time. Undersigned counsel had no idea that Judge Glanville, Lawyer Love, and Lawyer Hylton would dodge the law and ethical rules to conduct this improper and unethical ex parte conference. Judge Glanville and Lawyers Love and Hylton were duty-bound to immediately announce to Mr. Williams, his counsel, and all accused in their counsel that this ex parte meeting occurred, that Brady and Giglio evidence was obtained, and that the transcript was made and allowed argument to flow. Instead, their cover-up equals their misdeeds. Judge Glanville, Lawyers Love and Hylton, acting in concert, hid Brady evidence and attempted to normalize this unconstitutional Star Chamber meeting, unethical conduct, and witness intimidation by deflecting the focus on how undersigned counsel learned of the secret proceeding. Judge Glanville held undersigned counsel in contempt of court. The misconduct by Judge Glanville, Lawyer Love, and Lawyer Hylton undermines trust in judges and prosecutors. It cannot stand and cannot be rewarded. Action must occur in order to attempt to remove this dark cloud over Mr. Williams' trial and the criminal justice system at large. The conduct of Lawyer Love, Lawyer Hylton, and Glanville can never be forgotten, normalized, or ratified. The Georgia courts have always safeguarded and separated prosecutors and their duties from judges and their duties. Here, there is no daylight between Judge Glanville and Lawyers Hylton and Love's improper and unethical conduct. So no sun shining there. All must be removed from Mr. Williams' case. As stated herein, Mr. Williams intends to call Glanville as a witness at trial, as well as at this recusal motion's evidentiary hearing, based upon his improper conduct and the need to make a further record to protect Mr. Williams' constitutional rights. Specifically, there appear to be communications not captured on the transcript of June 10th, 2024. So this is the second time in this motion they've said that. Lawyers Love and Hylton and Judge Glanville's examinations are needed to complete this record. And this is important because that's the basis, right? We need them to be witnesses. Not just because we can't see from the transcript what they were doing in that record, in what was recorded in that transcript, but because the record may be incomplete. There could be Brady and Giglio information that wasn't captured on the record. We need them as witnesses because otherwise, without it, our client wouldn't have the due process he's entitled to under the Constitution. Judge Glanville is a necessary witness in Mr. Williams' trial, and his name will be used when undersigned counsel cross-examines Copeland when asking questions. 1, whether Judge Glanville pressured Mr. Copeland to testify. 2, whether Mr. Copeland realized that Judge Glanville was allowing wrong propositions of law to be explained to him. And 3, the fact that Judge Glanville condoned Mr. Copeland lying under oath unless it was a bold-faced whopper. Now, play pretend, guys. What do you think? How do you think if Woody gets back on the stand, if this continues and he's asked questions about this, how do you think Kenneth Copeland, Lil Woody, would answer questions about Judge Glanville? Were they trying to pressure you to testify? Were you realizing that things weren't being explained to you correctly? Did you trust how they were explaining things? Or did you only trust how Kayla was explaining things to you? And was it true that Judge Glanville seemed to be okay with you lying under oath unless it was a huge lie? How do you think Lil Woody and Kenneth Copeland would respond on the stand if asked these things by defense counsel? Do you think it would be a favorable response to Judge Glanville and Hylton and Love? Or do you think it would be kind of what people in the chat are saying? This mandates that Judge Glanville not be in the courtroom in front of Mr. Williams' jury ever again as judge. Judges must be disqualified in proceedings in which their impartiality may be reasonably questioned, including but not limited to instances where the judge is likely to be a material witness in the proceedings. Grounds for recusal are contained in OCGA 1518, as well as the Georgia Code of Judicial Conduct. Further, the judge should be disqualified for bias against the party if such bias stems from an extrajudicial source and results in an opinion on the merits on some basis other than what the judge learned from his participation in the case. The alleged bias of the judge must be of such nature and intensity to prevent Mr. Williams from obtaining a trial uninfluenced by the judge's bias. In the case at bar, it's impossible to honestly find that Judge Glanville is an impartial, fair jurist. Recusal is mandated. Under Rule 211 of the Code of Judicial Conduct, a judge must avoid all impropriety as well as the appearance of impropriety. Judges shall disqualify themselves in proceedings in which their impartiality might reasonably be questioned. So this is a lot of case law. We know this is If there's the appearance or if it's actual, he's got to step down from a ruling about his own recusal. Um, let's see. More case law here about impartiality. And then the bias, they're going to argue that the judge it goes beyond just the appearance here. So they're saying the bias of Judge Glanville is of such a nature and intensity to prevent Mr. Williams from obtaining a trial free from Judge Glanville's bias and prejudgment. Prejudice, bias, or prejudgment, or even an exhibition of partisan feeling is present in Mr. Williams' case, and Glanville must be removed. Mr. Williams asked this honorable court to hold an evidentiary hearing on this motion to recuse in order for Mr. Williams to gain a full understanding of the misconduct of lawyer Love, lawyer Hylton, and Judge Glanville throughout this case. Judge Glanville is so involved in this controversy that his objectivity can reasonably be questioned, and he must be removed as a judge over Mr. Williams' trial. So I hope if this is granted, if this moves forward, I mean, they could just say, all right, we're recusing. We're going to recuse, we're going to grant it. But this evidentiary hearing, can you imagine watching these things that we're seeing in these motions argued on the floor? And then the response arguments? We will tune in. The facts are so clear that Judge Glanville, in order to shield himself from his co-prosecutor and his co-prosecutors, Love and Hylton, from the truth of their misconduct, denied Mr. Williams' June 17th motion to recuse without a hearing, without providing a transcript, and without permitting another court to hear the motion to recuse dated Monday, June 17th. This demonstrates that Judge Glanville is involved in this controversy and cannot be deemed fair and impartial. The rules of disqualification pursuant to OCGA 1518, as well as the Code of Judicial Conduct, are in play. And then significantly, Glanville's required to avoid not just the impropriety, but the appearance. This is because the public confidence in and respect for the judiciary and our courts must be maintained. And guys, you guys have been saying, we don't have confidence in this. This is shady. This seems corrupt. Long before the transcript even came out. And the transcript just validated that. Like, has anyone read the transcript and actually felt more favorably to the prosecutors or the judge? At least in a significant way? Did anyone feel significantly moved by the transcript, that they saw Judge Glanville and the prosecutors in a better light? So as shown in Exhibit A, we're going to get to that. The shocking conduct of Love, Hylton, and Glanville proves that bias and prejudice have been shown, and it would be error for Glanville to continue with the case. It has been held to be elementary that a judge... They're saying it's such a simple concept. It's known, even if, like, it's an elementary thing to know. But we're speaking about a chief judge. It's an elementary concept that a judge must be disqualified when he is going to be a witness in the same proceeding. And that's it. That's the whole sentence. In the case of Judy's, Judge Glanville has taken on the prosecutorial role against Mr. Williams and hence must be recused. These circumstances illustrate perfectly the inescapable conclusion that Judge Glanville is partial to the prosecution and biased against Williams. Judge Glanville attempted to cover up his and lawyer Love's and lawyer Hylton's misconduct by attempting to intimidate undersigned counsel. I'm assuming the contempt, right? So, and then holding undersigned counsel in contempt of court, sentencing undersigned counsel to the maximum number of days to serve in custody for doing nothing but zealously and ethically upholding his professional responsibilities. Now, what did we just see the Supreme Court say about a different judge, a probate judge, who held a party in contempt for the maximum sentence? What did we just see the Supreme Court say about a judge without a reason, without a justification, choosing the maximum sentence to hold someone in contempt? Supreme Court doesn't seem to like that much. Judge Glanville then took action before the jury after recusal motions were timely filed by the Honorable Douglas Weinstein, as well as undersigned counsel. All of these actions taken by Glanville after these ripe and valid recusal motions were filed are void. Judge Glanville has caused Mr. Williams immeasurable suffering and prejudice based upon his, lawyer Love's, and lawyer Hylton's denial of Mr. Williams' statutory and constitutional rights. Mr. Williams must be granted a reasonable bond. Right, because they're still sitting in there. Which was kind of an issue. Like, it was a limited request from Adrian Love yesterday. We just need 48 more hours. We just need 48 more hours because I had an emergency. But at the same time, this motion that you're asking for an extension to respond to, you've got all these people sitting without bond. You've got an unsworn witness just hanging out. You've got, I mean, a sworn witness. You've got a sworn witness hanging out. You've got a jury that's just kind of like, well, we were supposed to come back on the 8th, and now it's the 9th, and we're hearing that everything's just paused. We don't know when we come back. Love needs 48 more hours because another ADA can't help write the motion, can't help get it done. Meanwhile, we get this, I think this is like 30 pages of a supplement here. And then the attached exhibits make it 233 pages in total. Meanwhile, we're able to get this huge document. Like at the same time, the state needs more time to respond to the recusal. Mr. Williams must be granted a reasonable bond. Mr. Williams' statutory right to a speedy trial has been totally upended by lawyer Love, Hylton, and Judge Glanville, and Mr. Williams must be cleared of all baseless charges. As spelled out above, the supplement to motion to recuse is timely filed as same is filed, not later than 5 days after we learned about the transcript. The attached joint affidavit, so we're going to get to that, supports this recusal motion by giving fair support to the charge that Glanville's bent of mind may prevent or impede impartiality as required for Judge Glanville to preside over this case. Judge Glanville's extrajudicial misconduct cannot be ignored. Judge Glanville, Love, and Hylton have worked in lock and step to ensure that Mr. Williams' constitutional and statutory rights to a fair trial, impartial tribunal, due process, right to be present at all critical stages of this trial, under the federal Constitution, as well as Article 1, Section 1, Paragraph 12 of the Georgia Constitution, the right to cross-examine, right to present a defense. This is the laundry list, you guys. Right to effective assistance of counsel, right to assist his counsel have all been crushed. This trial is a farce. A farce. Denying this motion to recuse and permitting Judge Glanville to continue as judge perpetuates injustice. This case can never return to constitutional normalcy based solely upon the improper misconduct of Love, Hylton, and Glanville. Any tragic conviction and sentence in this case will likely be reversed. Judge Glanville has made himself a necessary witness, as has Love and Hylton. Should Glanville not recuse, Mr. Williams would be prevented from exercising his constitutional right to call witnesses, as Mr. Williams needs to show the jury how and why Love, Hylton, and Glanville were not just doing their jobs, but were teaming up with a united front to convict Mr. Williams. Once armed with this evidence, the jurors can then properly determine what, if any, of this testimony and these facts will bear on their verdicts. Judge Glanville must be removed. So they're going to say that it was timely again, the initial motion to recuse, and they need Judge Glanville to answer a legal question. This is simply a question of law. I think this is rehashing a lot of the initial arguments here because they're citing back on June 18th to that hearing on that day. So they're just going through the timeline of when we were filing everything. On Monday, we know that Glanville let these motions to recuse be forwarded to another court. It got assigned to Rachel Krause. And then we know that they're probably going to say we're trying to get non-superior court of Fulton County judges on it. And then here, we want this hearing. So a hearing must be held to properly document the misconduct between lawyer Love, Hylton, and Glanville. So we want this hearing so we can get this on the record. A full evidentiary hearing must be conducted where Love, Hylton, and Glanville will be called by undersigned counsel as witnesses to determine the nature and scope of their relationship and misconduct. Now, this is just a small aside, but kind of on a smaller level. The attorneys, the criminal defense attorney, Frank Prieto, in the Courtney Clenny, the OnlyFans murder case, he was just called to the stand because he needed to answer some questions about group chats that may have been used in furtherance of their client's defense and possibly involving parents, which they may have also had an attorney-client relationship with. Well, the state prosecutors just went in there and were looking through these communications. They didn't filter them out. They didn't process them through the taint team. So they're looking at all these attorney-client privilege information, these conversations. And then they tried to argue to the judge in that case, Laura Cruz, well, we were looking for evidence of a crime they might be committing to try to cover something up after the fact, which isn't really a basis of law. The judge ends up finding in favor of the the Clenny's defense. But in that case, just for that small matter, the attorney had to take the stand and had to be questioned, had to give context. And it turns out that the judge didn't find that attorney did anything wrong. In fact, the judge found that the prosecution overstepped their bounds and violated attorney-client privilege. So a little bit of prosecutorial misconduct there, but they actually put the defense attorney up on the stand as a witness. The prosecutor never had to become a witness. So think about the difference. That's a slight parallel in concept, but the circumstance, the context here, with what lawyer Hylton, lawyer Love, and Judge Glanville were doing, and why the defense attorneys are asking for them. We want this evidentiary hearing. We want to be able to question them. There's a much stronger basis here, a much stronger reason why we need to talk to Hylton, Love, and Glanville. And I think I want to see it personally just because I want to see it, but I think in terms of being entitled to this, I think they're entitled to it. So before the jury, Judge Glanville will be spoken about in terms of his work as a member of the prosecution team. So they're letting them know, if this case picks back up, you guys, when we talk about Judge Glanville in front of the jury, he will be spoken about in terms of his work as a member of the prosecution team, as a cohort, as someone working in concert with Love and Hylton. Judge Glanville will be called as a witness by Mr. Williams. The law mandates that Judge Glanville be removed from presiding over Mr. Williams' case because he cannot be both a witness and judge in our lawful criminal justice system. Judge Glanville has given lawyer Love, lawyer Hylton, and Honorable Attorney Bumpus and witness Copeland. Now remember, they're doing this again. It's just judge and lawyer, and then we get an honorable for not them. So Honorable Attorney Bumpus and witness Copeland legal advice. Mr. Williams' jurors need to understand who has been orchestrating this kangaroo court. Judge Glanville, lawyer Hylton, and lawyer Love should have separate and distinct roles in our criminal justice system. This distinction, hey, we got another typo, between these roles have been washed away in Mr. Williams' case. When the judge instructs Mr. Williams' jury that by no comment, ruling, or action taken by the trial court should the jury determine that the judge has any bias in favor of a party, this will be a disputed point of law. Mr. Williams will be calling Judge Glanville, Hylton, and Love as witnesses, and thus this instruction does not apply to Mr. Williams' case. Mr. Williams' jurors must learn the conduct of these three lawyers when examining the evidence and evaluating this instruction. Judge Glanville is a necessary witness in Mr. Williams' trial and must be recused. Lawyers Love and Hylton are necessary witnesses in the case and must be disqualified. And then in Exhibit A, so in the new affidavit from Adams and Steele, Judge Glanville received extrajudicial information and also gave opinions and legal advice that included, but are not limited to, that Mr. Copeland went to prison for crimes committed on behalf of YSL, a contested fact in this trial. 2, Mr. Williams and other co-indictees know Mr. Copeland and his criminal conduct that is not known to Judge Glanville or the prosecutors. 3, Mr. Copeland will be cross-examined on his other crime evidence because Mr. Williams and the co-indictees have far greater knowledge of Mr. Copeland and his background than others. And 4, the like. By embracing this extrajudicial information, Judge Glanville believes that Mr. Williams is involved in criminal activity with Mr. Copeland, and Judge Glanville expressed that fact to Mr. Copeland in order to push Mr. Copeland to testify against Mr. Williams. These conclusions regarding facts that are in dispute about Mr. Williams' guilt mandate Judge Glanville be removed from this trial, because this is not a bench trial. This is a jury trial. So the judge isn't supposed to be making conclusions of the fact. They're supposed to play basically referee to determine what each side can present to the jury so the jury can make a determination of fact. So that sounds problematic. Moreover, Judge Glanville's derogatory and prejudicial statements and demeanor must be considered by this honorable court as attached in Exhibit A. Judge Glanville had an ethical duty to disqualify himself in this matter, as he clearly has a personal bias and prejudice concerning Mr. Williams and other co-indictees, Mr. Williams' counsel, and the other defense lawyers in the case. Judge Glanville has violated his oath by not voluntarily disqualifying himself to avoid this impropriety and appearance of impropriety. Instead, Judge Glanville, lawyer Love, and Hylton have manufactured. That's a big word. They've manufactured this. They've manufactured an unfair, unconstitutional, broken trial and has caused Mr. Williams severe prejudice by incarceration for over 2 years without bond and a laughable trial that has lasted entirely too long with the games played by Love, Hylton, and Glanville. Glanville must be removed. So the stuff that we're going to look at, it's more than mere friction between zealous counsel and a diligent jurist. Glanville's conduct created the realistic impression that he has harbored an inclination to be biased against Mr. Williams and partial towards lawyer Love and Hylton and the Fulton County District Attorney's Office. Although proven, this honorable court need not decide whether such bias or impartiality actually exists, because Glanville's ethically bound to disqualify himself when the impartiality might be reasonably questioned. And you guys are all reasonably questioning it. So, including instances where Judge Glanville's behavior could indicate that he has personal bias or prejudice against a party or party's lawyer. So, it would be error to permit him to continue on Mr. Williams' trial. And then we're going to get to this affidavit, but he should be disqualified from any contact with this case moving forward, based upon his bias against Williams and or his counsel, which stems in part from extrajudicial sources, out-of-court sources, and results in an opinion of the merits on some basis other than what Judge Glanville learned in his lawful participation of the case. So cited above, these ex parte communications are presumptively harmful error, and the state has the burden of rebutting them. And then let's see. They're going to become witnesses because we need them. We need to explain this injustice to the trier of fact, the jury. Judge Glanville, Hylton, and Love have stolen Mr. Williams' opportunity to have this trial heard by a jury in a constitutional and statutory firm manner. Judge Glanville, lawyer Hylton, and lawyer Love have goaded. And remember, the state was just trying to say that that Max Sharp was goading a witness. But now, on the flip side, Steele and Adams are saying Glanville, Hylton, and Love goaded Mr. Williams into moving for mistrials. All of the conduct in all the proceedings after the Honorable Doug Weinstein, as well as undersigned counsel, filed their motions to recuse and affidavits, are deemed invalid and have no effect. Mr. Williams' constitutional and statutory right to a speedy trial has been stomped on by Glanville, and also his right to due process and a fair tribunal and other constitutional rights have also been stomped on. This conduct must end and disqualify all three of these lawyers. So it looks like we're getting into this affidavit, you guys, which is, I think, we're going to get these bullet points. They are also going to say here that there's a systematic pattern of prejudicial conduct, and it extends beyond Hylton and Love. It extends to the District Attorney's Office of Fulton County. These aren't bare conclusions or opinions. Instead, Judge Glanville was using his position of power and trust to obstruct justice as he has violated his oath of office, while Hylton and Love sat mute. And I do think, guys, if we have time, we can go and watch that clip again, because they really do. If you guys watched June 7th at all, if you watched June 10th at all, the body language from the bench and from the prosecution's table, and not even just Love and Hylton, but there's usually three guys. I think maybe it's two guys and one girl, but I think it's three guys that sit at the table behind the table that Love and Hylton are at. The one guy, every time a defense attorney was getting up and making an argument, someone on the prosecution's team would look like, oh, and watching that body language is pretty telling, especially if you watched it in that moment, not going back now and looking at it, knowing everything we knew now. It was still palpable. We didn't know the full scope of what was happening, but you could still sense, you could still read the room that something wasn't right. So, as explained above, and they're going to repeat that ex parte, it's presumed to be an error. They have the burden. We're going to skip through, and I'm going to update the description to include the document link. Sorry, guys. I had a StreamYard blip because my windows weren't resizing, but I'll go and add this document. ThuggerDaily also posted it. Judge Glanville had the duty to disqualify himself. We've seen that case law. And the law also requires this honorable court to recuse. Now, this is important because we haven't seen this in a motion from Steele and Adams yet. We've seen Doug Weinstein argue for this. Doug Weinstein had filed the motion last week to disqualify any Superior Court of Fulton County judge from hearing this. Take it outside the county. So here, Brian Steele is adopting that same argument. The law also requires this honorable court to recuse. The public must believe in the absolute integrity and impartiality of judges. That is why, even without a showing of actual bias, prejudice, or unfairness, and regardless of the merits and timeliness of any motion to recuse, it's inappropriate for any judge to preside in an action where one of the parties holds judicial office in any other court which sits in the same circuit. So this is the same argument we've seen Weinstein make. And shout out to them, man. Weinstein and his team have really been pounding the pavement too. And Weinstein's been doing a lot of interviews too to talk about the case. And I believe Weinstein has also said he's also interested in seeing a recusal for Love and Hylton. So it's not just Steele and Adams and Jeffrey Williams. It expands beyond that to the co-defendants. The Supreme Court of Georgia observed that our Judicial Qualifications Commission has opined that a judge in a particular court should never preside over a matter concerning another judge from the same circuit. So all of this, and it kind of seems obvious on the surface, right? We shouldn't have our own friends, hearing a friend's motion to recuse. But there's law. It's not just a gut feeling. There's also law. So this honorable court should recuse from this case because refusing to do so would permit questioning of this honorable court, something the court will not countenance. This court must recuse as well. And then they're going to cite these. We talked about the donations at the beginning, but if you missed it, in April of this year, so well after the YSL trial started, Judge Glanville sent a $2,000 donation for the election campaign of Rachel Krause. And then also in April of 2024, Rachel Krause sent a $500 donation to the re-election campaign of Judge Glanville. So a little bit of donations going back and forth. And that might not be nefarious, right, on the face. But it goes to bias, impartiality. Judge Glanville's donation to this honorable court's re-election campaign 3 months ago, coupled with the above cited case law and Judicial Qualification Commission opinion, mandate that this honorable court recuses from this case. And then we get this signed off, and we're going to get to the affidavit, you guys. We have the affidavit. Let's get to Exhibit A. So I think this, and we're going to jump to the emails. I think this is going to be really, really interesting. And then shout out to Dear Woke Christian. I'm sure Dear Woke Christian is going to be doing some content on this. So if you guys don't know that he has a channel, it's Dear Woke Christian. If Drea or Ghost, if you're in here, if you have the chance and can, if you can drop a link to Dear Woke Christian's channel, that'd be awesome. He says, grace and peace, dropping support to one of the best in the game. Keep up the fantastic work. Thank you so much. So let's see. Take some water. You guys are on fire in the chat. And we have another footnote in the title, you guys. Look up here. If you missed the beginning, you guys, on page 1 of this, there were 3 footnotes attached to the motion title. Now this affidavit has a footnote. Love that. Love that. So this footnote here says this affidavit also moves to recuse the Honorable Fulton County Superior Court Judge Krause hearing the motion, the recusal motion is stated herein. So following that same argument, we don't want Krause hearing this, and probably not any Superior Court of Fulton County judge. So again, this affidavit is from Brian Steele and Keith Adams, which is nice because Keith Adams is kind of, sometimes we don't hear from him as much, but he's part of the team. And now you've got 2 people on the sworn affidavit. I don't know if that makes it since they're representing the same client. They have shared their, counsel of record for the same person. But it is still swearing on this affidavit. So they're over 18. They have no legal disability. And they're making this based on their personal knowledge. We're counsel for Jeffrey Williams, young thug, in the above styled case. And we're filing this affidavit on July 8th, which is 5 days from the July 1st transcript release, not including Saturday and Sunday, so it's timely. Affiants hereby expressly adopt and embrace all statements made in the motion to disqualify/recuse Judge Glanville and the joint affidavit attached thereto, dated June 17th, 2024, and rely on that timely filed and asserted motion to recuse as well as the affidavit in total herein. Judge Glanville met with love. Here we go again with the characterization, you guys. Look at the wording. Judge Glanville met with lawyer Love. the Honorable Attorney Bumpus, and then back to Lawyer Hylton. We go from Lawyer Love, Honorable Attorney Kayla Bumpus, Lawyer Hylton. At times, the court reporter, sworn witness Kenneth Copeland, members of the District Attorney's Office, including but not limited to Fulton County District Attorney's officers, investigators Long and Hamilton, as well as members of the Fulton County Sheriff's Department, outside of Mr. Williams and his counsel's presence, and discuss critical parts of Mr. Williams' case in violation of his constitutional rights to, that laundry list again: fair tribunal, right to be present, right to due process, right to assist counsel, right to confront witnesses. The purpose of this ex parte meeting between Lawyer Love, Lawyer Hylton, and Judge Glanville was to act in unison in order to influence sworn witness Mr. Copeland to testify against Mr. Williams. Put a 1 in the chat if you agree that that was the purpose of this transcript. Put a 1 if you agree with what Steele and Adams are saying was the point of this ex parte. And then put a 2 if you think that's not a reason, if you disagree. There was absolutely no lawful purpose for this ex parte hearing to occur, to wit. There was no allegation by Mr. Copeland that he was somehow threatened. There was no allegation by Mr. Copeland that he was not satisfied with his counsel. There was no allegation by Mr. Copeland that he needed to meet with Judge Glanville. And they cite the transcript here. Instead, this ex parte meeting was orchestrated by Lawyer Love, Lawyer Hylton, and Judge Glanville to convince Mr. Copeland to testify against Mr. Williams. This influencing a witness meeting eviscerated any appearance of regularity of the tribunal and demonstrates at the very least that Glanville is biased for the prosecution and against Mr. Williams and his counsel. Lawyer Love begins this unethical ex parte conference by explaining that the state's reasons for Judge Glanville to meet with sworn witness Mr. Copeland is to impress upon Mr. Copeland that he needs to testify for the same reasons Lawyer Love announced in open court on Friday, June 7th. The Honorable Jonathan Melnick abandoned his client. So they're giving this timestamp 4 hours and 28 minutes into, this might be like Law and Crime or 11 Alive. It might be their stream. But it's giving about 7 minutes here of Love making arguments to the court and saying, like, look, she gave her reason in open court. It wasn't a secret. There isn't some reason that this is privileged. She made Melnick the issue. At this point, rather than acting as a true judge, protecting our court system and its reputation by questioning, why am I meeting ex parte? And why am I being used to answer, in front of only members of the state of Georgia, questions of Mr. Copeland? Judge Glanville, because he is biased, agreed to help convince Mr. Copeland to testify, adverse to the liberty of Mr. Williams. And then I happened to look over and catch this. Okay, so this is actually important. So Ricardo Cook says, Steele just filed an amended motion with a correction. Krause didn't donate to Glanville, but Glanville did donate $2K to Krause. And that kind of makes sense because did Glanville have a re-election in April? So it makes more sense. I don't think he did. Did he this year, 2024? So that's a good correction, though. Pretty important correction. It doesn't change my mind, but, accuracy is accuracy all the time. And then at this point, rather than acting as a true judge, protecting our court system and its reputation, wait, I read this part. We're down here on 8. Lawyer Love made untruthful statements about email if you guys looked at this transcript, like everybody raised their eyebrow at this. Is Dear Woke Christian still in here? Because we had to take a moment of pause. When we were looking through this transcript, we said, hold on. She blathers on for paragraphs, giving her own characterization of these email statements. But the part where he says F you, he yells F you in this email, all of a sudden, Love, after paraphrasing and making up her own characterization for like 2 or 3 paragraphs, all of a sudden she runs to quote exactly what the email said when it comes down to Melnick saying F you. And we stopped and we're like, well, why couldn't she just read the whole correspondence? Why did she want to paraphrase the context leading up to Melnick saying F you, but wanted to read the exact quote of something that offended her personally? And here, Steele and Adams are saying Lawyer Love made untruthful statements about email correspondence with the Honorable Jonathan Melnick. See Exhibit B, pages 3 through 5. So they're quoting that part of the transcript from the ex parte. There's also Exhibit I. Do you guys want to jump to the email right now? Let's jump to I. So we're on page 31. Let's look at this attached exhibit with the emails with Melnick. Let's do that. Let's do that right now. And then we'll come back up to bullet point 9. So exhibit I. This is going to be a lot of scrolling, you guys. I'm sorry. I'm sorry. Maybe I can search exhibit I. No. Ah, there we go. Yes. So let's see. And hopefully this is in, oops. Hopefully this is in top to bottom order. Um, let's see. All right, so this looks like it was, this up here says the 8th, but down here it says the 6th, June 6th, from Jonathan Melnick to Adrian Love, also the Steele Law Firm, Max Shart, and Symone Hylton. And CC'd is Antonio Long with the District Attorney's Office. And the subject is regarding Kenneth Copeland. So again, this is June 6th, and we're looking down here. Let's see. Do we have a timestamp? 5:48 p.m. I think this is in reverse order, you guys, because this says 5:48. This says 4:57. So maybe I should start from the bottom and go up. Or let's just read it in this order, but understand that we're reading from top level replies, most recent replies, and working backwards. So here Melnick says to Love and all the attached, I have been Mr. Copeland's attorney. He tells me that he repeatedly told you that when you were questioning him. So he's been telling you that I'm his attorney. He's told you multiple times. And we learned from the transcript that Hylton was meeting with Woody a couple times from the Friday before June 7th up through June 7th. Meeting with him one-on-one. She doesn't mention anyone else being there. And here on June 6th, that Thursday, Melnick is saying, Copeland's telling me that he keeps telling you I'm his attorney over and over. But in that transcript, they say, we didn't know. Nobody told us. Kenneth didn't tell us. So Melnick goes on to say, I also spoke with Don Geary extensively about Mr. Copeland when he was signed to the case. So Don Geary was almost prospectively going to be the prosecutor, the lead prosecutor in this case, from what I understand. And he ended up, Love is now the lead prosecutor, and Don Geary no longer works with the office. He took a different position somewhere else, from my understanding. But that's who they're referencing here. That's a broad generalization. So Melnick speaks with Don Geary extensively about Mr. Copeland when he was assigned to this case, and I spoke with Miss Love early in the process, around the time jury selection was beginning. I have a plea with Judge Carnsdale tomorrow at 9, and I will come into the courtroom as soon as I'm done, which we got to see. We got to see. And then, so we're working backwards again. So his reply was a response to this message at 4:57 p.m. from Symone Hylton. Symone writes, good afternoon. I hope all is well. In our conversations with Mr. Copeland, he advised that you were not his attorney and he had not spoken with you. However, if you are asserting that you are his attorney, we will cease communication. But your client is under subpoena and is expected to be here at 8:30 a.m. It is our understanding that your client does not have transportation, so we were planning to pick him up. So please make sure that he is present so we do not have to take any further action if he fails to appear for his subpoena. That's confusing. We were going to plan to pick him up, but now we're not anymore. Now it's Melnick's job to make sure he's present, even though we're expressing uncertainty. So we do not have to take any further action if he fails to appear for his subpoena. Thank you and have a great evening. Honestly, I think that they would relish in the excuse, the opportunity to say, oh, he failed to appear. It wasn't on us to transport him anymore. Let's hold him in contempt. Let's pick him up. Yours in service, and then Symone Hylton signs off. And then before that, at 4:31 p.m., so not too long before Hylton responds, Melnick says to Adrian Love, with Hylton copied in, as well as Steele and Shart. So it looks like Steele and Shart I wonder if we're going to see when they're CC'd in. So, good afternoon, all. It has come to my attention that the Fulton County District Attorney's Office has questioned my client, Kenneth Copeland, without my knowledge or consent. Please be advised that my client does not wish to speak with any member of the Fulton County District Attorney's Office, nor any law enforcement officer from this point forward. My client will assert his privilege under the Fifth Amendment tomorrow and will not testify. Now, are you guys getting This really isn't how Love represented this in the ex parte meeting. And there's no re here. This looks like the first email because it just says Kenneth Copeland. It doesn't say re colon. So 4:31 p.m. on Thursday, June 6th. Melnick is saying, my client's going to assert his Fifth Amendment privilege tomorrow and will not testify. Thank you. Yeah, we are reading the emails backwards, you guys. And then this is certified. Let's see. This is the end of it, right? So this is the certificate of service for the whole 233 pages here. So yeah, this is important because we find out here on Thursday for sure that he planned to assert his privilege. And then on Friday morning, they run and try to make sure that this immunity agreement is in place. And it's also important to note that Shart and Steele are CC'd through all of this, right? So they're already aware that this witness, they might not know the surrounding context, but at the very least, at this point in time, they know this witness plans to plead the Fifth and that the prosecution is aware of that. And then let's see. Let me go back up. Let me start. What was it? Exhibit A, right? That was the first exhibit. Was because I don't know what page that was. Like page 33. I don't want to put you guys through like 200 pages of scrolling. And then 8 of that pseudos. Brian Steele put the emails front to back because we know people will scroll to the bottom, and he wanted to ensure people saw pled the Fifth. That's a good point. That's a good point. Because typically when you copy emails, if you copy from the top, the most recent reply is at the top. But a clerk, an associate, someone could have reordered how it was presented. That's a great point. You scroll all the way to the bottom. You look for that certificate of service. You say, well, what happened last? And then the first thing you see is John Melnick. He's going to plead the Fifth. But yeah, and then Q, shout out to Q. How are you going to speak with him about an immunity agreement after his lawyer invoked his privilege? Well, we're going to run and get an immunity deal so he can't do that. And we're going to keep all of this out of the purview of defense counsel. Now, I'm still unclear when the immunity was disclosed. Did Brian Steele and all the other defense counsel, did they only find out about that immunity because in open court it was talked about on June 7th? Or were they like sent an email? Were they told, like, hey, here's a copy of the immunity agreement that we just signed? Because the defense has the right to know if any pleas or agreements are made to a witness, because that agreement could go to that witness's credibility, and they have the right to confront certain things. So that's an interesting question too. And then shout out to Heart of Inspiration. Heart of Inspiration, you guys, obviously her current channel deals with inspirational content. But yesterday she said she also wants to start a pilot, a sister channel to talk about cases like this. And full encouragement to you, Heart of Inspiration. Thank you for the $5 super chat. You're saying you're doing an amazing job as always. Love you too, Heart of Inspiration. And then Penny G. So the FU and getting him killed is a lie. I'm not sure. But that's a good point, Penny G. So earlier, back to the motion, the supplement, where they're saying, like, look, we have no knowledge from Mr. Copeland that Mr. Copeland was scared. They word it that Mr. Copeland has not said. He did not say during this ex parte hearing that he was scared. They do word that in a way that if Melnick had said as much, you're going to get him killed, in another email correspondence. That it was only Mr. Melnick saying that. So they do word this, Mr. Copeland himself. We don't have him saying that on this transcript. So I think that's where it's not necessarily saying that that didn't happen or that email doesn't exist. I believe Melnick talked about that with Kayla Bumpus on her channel, that he did in fact send that email. And maybe he would have reworded it, but whatever. So it seems like Melnick today is still saying, yes, I sent this FU email. But I think if you think about the way this is worded by Steele and Adams, it makes more sense. They're focusing on Kenneth Copeland's own words. So let's see. We were back on bullet point 9 here. Let's see. Lawyer Love continues to make false representations, and Judge Glanville knows. If he has paid attention at all during the proceedings, that Lawyer Love makes intentional misstatements of fact routinely. Yet, Lawyer Love deflects her misconduct and cites the ethical rules of conduct for attorneys during this ex parte hearing. Lawyer Love explains the need for the ex parte communication. All that aside, we would like an opportunity for what? For the court to address Mr. Copeland and Mr. Copeland's stand-in counsel present, to allow Attorney Bumpus an opportunity to explain to Mr. Copeland everything that Lawyer Love has just said. See Exhibit B, pages 3 through 6, specifically page 6, lines 2 through 8. Again, Judge Glanville has thrown away all appearance of propriety by permitting this ex parte meeting to occur at the behest of Lawyer Love and or Lawyer Hylton. Judge Glanville is not independent and is being led by the nose by members of the Fulton County District Attorney's Office. This is because Judge Glanville is a member of the prosecution team. And then they see Exhibit B, the entire transcript. That's funny. Judge Glanville then adopts the wrong law offered by Lawyer Love that Mr. Copeland will be held in custody until he testifies. See pages 5 through 7. So this is when Love was still in the meeting and Hylton was still meeting with Copeland downstairs, wherever they were. Lawyer Love seems to somehow assert that Mr. Copeland can be kept in custody even after Mr. Williams' jury is discharged. Judges are presumed to know, respect, and comply with the law. Objectively, Judge Glanville permits several misstatements of law in order to have Mr. Copeland testify against Mr. Williams in order to assist the prosecution. Judge Glanville becomes an advocate for Mr. Copeland to testify against Mr. Williams by telling Attorney Bumpus how to communicate with her client, Mr. Copeland, specifically that Mr. Copeland is, and we're quoting, going to face some pretty significant cross-examination. Uh-oh. You don't want to just be up there by yourself without us helping you, do you? Like, they're saying that the undertone here, the nudging, the prodding, it's a bit of sticks and carrots, and the judge shouldn't be participating in that. So it goes on to say that Judge Glanville explains to Attorney Bumpus that it's all in the message and the packaging in terms of, I think, Mr. Copeland is, a savvy person. But he's certainly going to be subject to a thorough and sifting cross-examination. The fact that Judge Glanville is dispensing legal advice and strategies to Attorney Bumpus, guiding her on how to speak with Mr. Copeland in order to have her client testify against Mr. Williams, is a clear, direct fact that Judge Glanville has forfeited his judicial role. And then they're citing the Judicial Qualifications Commission and Rule 310, which states that full-time judges shall not practice law. See also, they got all the rules here. What is this? They got an opinion, an updated now Rule 310, and Rule 210A. So they've got 3 things here saying that that's no bueno. Judge Glanville is biased against Mr. Williams and is partial to the prosecution of Mr. Williams. Judge Glanville, along with Lawyer Love, continues to advise Attorney Bumpus what to tell her client. For instance, part of Mr. Copeland's challenge, Attorney Bumpus, may be that you need to ensure Mr. Copeland, hey, look, I'm going to be here. And if you think that they're asking you a question, they being the state or the defense, is asking you a question that's going to bring out other crimes that Mr. Copeland's going to be able to look to you and say, can I have a chance to speak with you? Lawyer Love, who is working in lockstep with Judge Glanville, states that's exactly right. So there you go. We called that out while we were reading the transcript. Yep, they were nodding along with each other back and forth. Lawyer Love then inaccurately bashes Attorney Melnick by saying, there's been an assertion that people are representing Mr. Copeland's interest. The biggest concern is Mr. Copeland's best interest, and then they are just not here. There is absolutely no reason that Judge Glanville and Lawyer Love are discussing what Attorney Bumpus should be telling her client, and no reason for Judge Glanville to permit Lawyer Love to ridicule Attorney Melnick. And I agree, because especially now that we got to see the email chain, and looking back at the transcript, thinking of the way that Adrian Love characterized, she summarized, she paraphrased, she took creative licensing with the email exchange. And then the only thing she wanted to quote was the FU, the thing that she took a personal offense to. And they're talking about all of that while Melnick's not allowed to be there. And in my opinion, I don't know if you guys are welcome to, we can diverge in our opinions here. But in my opinion, Love misrepresented and really didn't represent at all. She kind of just created like a fan fiction about this email exchange. That email exchange comes down to, why are you talking to my client? He's going to plead the fifth. And then Hylton responding like, well, make sure you're responsible for his transport then. How did we get like 3 rambling paragraphs from Adrian Love in the beginning of this ex parte meeting? Blah, 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 blah. And by the way, he also said F you. Like, quote the whole thing next time. Read the whole email exchange next time, Adrian Love. Lawyer Love again misrepresents by claiming that the Honorable Attorney Melnick has been talking to Brian Steele and Max Shart. And we called that out too. That's it. He's not talking to us. Why does Judge Glanville hold this ex parte conference and permit Lawyer Love to falsely accuse Affiant and the Honorable Attorney Maxwell Shart of obstruction and ethical violations by influencing a lawyer-client relationship? This is extrajudicial information that Judge Glanville should have never received. Judge Glanville continued to be a prosecutor of Mr. Williams when he instructs Attorney Bumpus that sworn witness Copeland can invoke the Fifth Amendment if he testifies about unrelated crime. Judge Glanville tells Attorney Bumpus that sworn witness Copeland is probably thinking about, there's a lot of stuff the defense could ask me about that is not known to a lot of people, and Mr. Copeland could also invoke the Fifth Amendment if it was some other particular crime. During this advice on what to explain to Mr. Copeland, Lawyer Love and Judge Glanville are speaking with one voice. This is Judge Glanville presuming and pontificating that Mr. Copeland is involved in a lot of unrelated crimes that Mr. Williams, a criminal himself, is aware of same. Therefore, Judge Glanville and Lawyer Love jointly explained to Attorney Bumpus that Attorney Melnick injected himself into these proceedings. The fact that Judge Glanville is having these conversations in the first place, then agreeing with and championing the prosecution's cause, mandates, even to a casual observer, they're talking about us again, the casual observers, that Judge Glanville is biased against Mr. Williams and favors the prosecution. Whew. Oh, and is Kayla in here? Oh my god, shout out to Kayla. Oh my god, I'm scrolling up, but I don't see. Okay, thank you so much, Drea, for sharing Kayla's link. I see people saying hi to her, but I don't see her. Let me scroll back down to the bottom. Kayla, if you're in here, I do have something to do at 1, but if we barrel through this and you want to hop up for a minute when we finish this affidavit, because your name is being dropped in here a bunch of times. In a good way, you're getting the honorable every time. So let me see, where was I? 17. This is a long bullet point. This great bias cannot be more clear when Judge Glanville explains to Attorney Bumpus that she needs to give sworn witness Copeland the questions that the state is going to ask him when he testifies, and to ask Mr. Copeland to tell Attorney Bumpus any other facts that they, meaning Mr. Williams and his co-indictees, might ask about. Further, as long as Attorney Bumpus, and remember, Kayla was there for the contempt. So why are they trying to get her to go further into future testimony that she may or may not even be aware of? And she expressed that she didn't have time to like prepare and catch up to everything that's gone on in the trial. So how could she even, if she wanted to and if she was given the time to, how would she even know all the context she would need to know to properly advise him? Because she was just stepping in that day. I see why this is a long paragraph. So further, as long as Attorney Bumpus has knowledge of other crimes that sworn witness Copeland has committed, Judge Glanville states that Mr. Copeland will be fine because the state is only going to get into the questions that was provided to Mr. Copeland. Yeah, only the state, not the defense. It is ridiculous to claim that Judge Glanville is not biased and is impartial. Judge Glanville continues explaining to Attorney Bumpus that the reason she needs to know from Mr. Copeland what crimes he has committed in the past is bold. This is bolded. The defendants know more about Kenneth Copeland than anyone else, so they are probably going to kind of. And then Steele and Adams go on to argue, what gives Judge Glanville the right to state that Mr. Williams knows more about Mr. Copeland's supposed bad conduct than anyone else? In reality, Mr. Williams hardly knows Mr. Copeland. Judge Glanville has pronounced guilt onto Mr. Williams. Judge Glanville imparts legal direction to Attorney Bumpus on how to prepare Mr. Copeland for cross-examination and how to prepare Attorney Bumpus to object on behalf of Mr. Copeland. Judge Glanville, and that's the thing. Why are you prepping her to... Thinking about it this way, it's like they expected Kayla to continue being there indefinitely, which we got that vibe for different reasons, but this is a bit more solidified of a reason. And they're complaining that Melnick injected himself, but then they're trying to forcibly inject Kayla Bumpus to have to stay for an indefinite period of time here while Kenneth Copeland's on the stand. And I'm sure that wouldn't have been a short period of time because we know how long some of those videos were. So Judge Glanville has tarnished this trial forever, as Mr. Williams could never have a fair trial with the way Judge Glanville has acted, both in front of the jury and outside of everyone's presence in the ex parte meetings with Fulton County District Attorneys and witnesses. Whew. The conduct of Judge Glanville, Lawyer Love, and Lawyer Hylton has caused them to be necessary witnesses at trial. Affy intends to call them as witnesses and cross-examine Glanville, Hylton, and Love on how many other ex parte meetings the three of them and any other member of the prosecution team have had. Judge Glanville cannot be judge and witness in the same proceeding. Lawyer Love and Judge Glanville, acting in concert, tell Attorney Bumpus that Mr. Copeland can cancel legal representation because Lawyer Love, Hylton, and Judge Glanville have done everything, quote, to clear Mr. Copeland of judicial exposure. Without any reason to believe that Mr. Copeland might be fearful for his personal safety, Judge Glanville injects his safety concern as a hypothetical reason that Mr. Copeland would not testify. Now that's an interesting catch-22, right? Because if they want to rely on Melnick saying you're going to get him killed, if Judge Glanville wants to now rely on that, you're going to get him killed, F you, that email. If they want to rely on that, then we see in the transcript that they don't ask Copeland himself any of those questions. And in my opinion, Adrian Love mocks the idea that Kenneth Copeland was at risk of being killed. She mocks that idea in the transcript. So I want to see a response to this argument just to see how they're going to try to justify it. Lawyer Love misrepresenting emails continues the theme of Mr. Copeland's personal safety. There is no evidence of the same. Judge Glanville tells Attorney Bumpus that Mr. Copeland has to give testimony, though. I mean, that's what he has to do. Mr. Copeland's got to give the testimony, whatever it is, good, bad, or indifferent. The questions must be asked. Why does Mr. Copeland have to give testimony? Is it because it favors the prosecution? Whose vantage point does Judge Glanville view this trial? Good, bad, or indifferent? To whose position? Judge Glanville must be recused. The court reporter announced off the record, Mr. Williams intends to call at trial Lawyer Love and Judge Glanville to determine what was discussed during this off-the-record time period. Judge Glanville has the audacity to bring sworn witness Copeland into his chambers without the request of Attorney Bumpus, but at the request of Lawyer Love. From 9:34 a.m. until 10:03 a.m., nothing is recorded by the court reporter. Affiant will call Lawyer Love, Lawyer Hylton, and Judge Glanville to probe what occurred during this time period. Once in custody, represented by counsel, sworn witness Mr. Copeland is brought involuntarily into Judge Glanville's chambers. Judge Glanville explains, I just want to bring you over and let you talk with Attorney Bumpus and see if there's anything that you need to ask of your counsel, or Miss Hylton, or the state, or the court, before we bring you out this morning, because we would like to hear your testimony, and it is kind of where we are at this point in time. It's hard to articulate how wrong this ex parte summit is. It's a summit now, you guys. The ex parte summit. And how obvious it is that Judge Glanville discarded the sanctity of the judiciary to become part of the prosecution team. Judge Glanville's biased, and this case is constitutionally broken because of the conduct of Love, Hylton, and another member of their team, Judge Glanville. I love that they keep citing, see entire transcript. They do it the whole transcript. Why is Judge Glanville inviting Mr. Copeland, a represented party, to ask questions of Lawyer Hylton or other members of the District Attorney's Office of Fulton County or the court? This is beyond comprehension for an impartial, seasoned jurist to act. This is because Judge Glanville is not acting as an impartial, seasoned jurist, but is part of the prosecution team and must be recused. I think they had like 30 points, so we're almost through this affidavit, you guys. Lawyer Hylton makes it clear that Mr. Copeland has never stated that he has a safety concern, which is stopping him from testifying. Hence, this whole safety concern discussed earlier was fabricated by Judge Glanville and Lawyer Love. Mr. Copeland states, "I have never been truthful a day in my life until I just made this statement right now." This is quintessential Brady evidence. Judge Glanville never uttered a word, nor did Lawyer Hylton or any member of the Fulton County District Attorney's Office to provide the defense notice of this Brady evidence. Same is unconscionable. Affiant intends to call Judge Glanville as a witness at trial, as well as Hylton, to discuss the failure to reveal this information, and for the jurors to be able to understand. The jury, and that's similar to when you see a witness on the stand and the defense is able to cross-examine, did you meet with the prosecution? How many times did you meet with them? Did they offer you anything in exchange for your testimony? You had warrants too, right? What happened to your warrants? Well, they were dropped. My charges were dropped. The defense gets to examine witnesses on stuff like this because those agreements go to the credibility of the witness. Do we have a motive to give truthful testimony? Or could we have the motive to give testimony that will maintain the plea agreement that got us out of, a conviction, out of a trial, out of being locked up longer, a longer sentence? So this is really important stuff. There's, Brady stuff is not something to play with. Because if you have a jailhouse snitch, there's a lot of cases around the country, a lot of Innocence Project cases that come down to a poor investigation, an eager prosecutor, and a jailhouse snitch. The key witness is just someone who's locked up and wants to get out. And the person presumably gets convicted off that testimony, and the jury isn't allowed to see that, they were offered $5,000 in cash if they came forward with information about a possible suspect. Those things are not supposed to be kept from the jury. The jury needs to have this information in front of them to decide who's credible and decide what is fact and what is not. So this is an important paragraph. Affiant intends to call Glanville as a witness. The jury has a right to know that when a judge reads the instruction that the court has no interest in this case except for a fair trial, same is not truthful as Judge Glanville is on the prosecution team. Judge Glanville, Lawyer Hylton, and Lawyer Love will be called as witnesses and have been added to Mr. Williams' witness list as announced by Affiant in open court. The fact that these three persons attempted to hide Brady evidence is beyond the pale. Judge Glanville instructed the jury that he has no interest in the case except to see a fair trial. Same is untruthful, and the jurors need to hear from these three witnesses in order to make the determination on whether same is truthful or not. Hylton gives inaccurate legal information on whether Mr. Copeland can be prosecuted at all, and gives some far-fetched ideas about the federal statute of limitations. They called it far-fetched. And the state of Georgia statute of limitations. And Copeland called that out. Judge Glanville sits idly by and allows Lawyer Hylton to misrepresent to sworn witness Mr. Copeland that he cannot be prosecuted for crimes. Anyone with a modest interest in this case would know that the prosecution has called Mr. Copeland an unindicted co-conspirator, and that the supposed RICO conspiracy statute of limitations continues today. Thus, Mr. Copeland could be prosecuted both in federal court and in the state of Georgia for crimes. This is wholly contrary to what Lawyer Hylton and Judge Glanville allowed Mr. Copeland to believe. Yep, and I remember looking at the chat when we did the reading, and then when I tuned into other streams, the whole chat was like, no. Moreover, Lawyer Hylton and Judge Glanville do not disclose either Brady evidence, as Lawyer Hylton explains that the state can assist Mr. Copeland with finding different places to live. This is part of an agreement that should be revealed pursuant to Giglio. Same was not done. Lawyer Hylton is a witness at trial and will be cross-examined by Affiant on these knowing misstatements to Mr. Copeland and the failure to reveal Brady and Giglio evidence. Same applies to Glanville. Hylton then tells Copeland, who at the time was a represented person, that he can speak with her without Attorney Bumpus present. Judge Glanville did nothing to stop this potential unethical conduct. Lawyer Hylton again tells Mr. Copeland that he's immunized from prosecution, while Glanville sits silent. That statement is not true, as Mr. Copeland received only use immunity. However, and it's crazy, guys, why did Judge Glanville sit there quiet when us casual observers in the chat were like, it's only use immunity, that's not everything, it's not literally everything. However, Judge Glanville reinforces Lawyer Hylton's wrong information, because Judge Glanville is a part of the prosecution team. Judge Glanville tells Mr. Copeland that he will not be prosecuted for any crime. Judge Glanville and Lawyer Hylton are acting as one, not separate as required by law. Judge Glanville explains to Mr. Copeland that if he is worried about what the defendants may ask you, because they may know your business, you can't be prosecuted for any of those. First, that is not true, since Mr. Copeland was only given use immunity to affiant's knowledge. However, it is clear that Judge Glanville is an assistant to the prosecution because Glanville, in order to help the prosecution, needs Copeland to testify and gives Copeland advice about cross-examination. Importantly, Judge Glanville again asserts that Mr. Williams and the other co-indictees may know your business, but if they ask you about things that you might think you might have some liability with, you can't be prosecuted for any of those. This presumes that Mr. Williams knows Mr. Copeland's criminal endeavors, because Mr. Williams is a co-conspirator with Mr. Copeland. And that would make what? Why isn't he part of this RICO then? Why is he the star witness instead? Judge Glanville is far from acting as an impartial judge. Mr. Copeland again puts an end to any made-up safety concerns and explains that he does not want to testify because he will set a bad example for his family based on his past misdeeds. So this is where we're getting into Hylton's life coaching advice on how on how Woody should sit down and talk to his nephews. One must ask, why is this ex parte conference occurring and why does it continue? The only logical answer is that Judge Glanville, Lawyer Love, and Lawyer Hylton, acting in concert, had an agenda to ensure that Mr. Copeland testifies against Mr. Williams in order to convict Mr. Williams. This is the definition of a biased judge and unethical prosecutors. This trial is constitutionally broken forever because of the outrageous conduct of these three public officials. Lawyer Hylton never provided to affiant the Brady material that Mr. Copeland had told her in the past that he was a liar. Judge Glanville sits mute and does not ask whether this Brady evidence was provided to affiant. Mr. Copeland explained that he never told Lawyer Hylton that the Honorable Attorney Melnick was not his lawyer, and thus Lawyer Hylton met with a represented party. Judge Glanville does nothing to discuss his potential ethical misconduct by Lawyer Hylton, Lawyer Love, and the other members of the Fulton County DA's office. This is because Judge Glanville is also a member of the DA's office of Fulton County. Lawyer Hylton told Mr. Copeland that he would be held in custody until every last defendant had been tried, not just the 6 on trial, the other ones too. Judge Glanville sits mute and delegates his judicial discretion of punishment to Lawyer Hylton because Mr. Copeland does not have to be housed in custody until every last defendant has been tried. So again, in that transcript, you see very clearly that Glanville and Hylton are like, yep, they're yesing each other. Judge Glanville, like Lawyer Hylton, attempts to intimidate Mr. Copeland by telling Mr. Copeland that if he chooses not to testify, Mr. Copeland would be held in custody until all 12 co-indictees' case comes to an end. This is just not true. In fact, Judge Glanville is not even the judge on the other co-indictees' cases, as same is being presided over by the Honorable Judge Dempsey. And then shout out, I see Vice's raid. Hey, Vice's peeps. Shout out to Legal Vices. And then let's see. Again, Judge Glanville and Lawyer Hylton failed to reveal to affiant Mr. Copeland's statement that I told the police whatever different story I could think of to try to finesse my way out of the situation. Instead of turning over Brady evidence, Hylton, with the support of Judge Glanville, explained to Mr. Copeland that he can simply testify, I don't recall. Judge Glanville, Hylton, and Love are inseparable and biased against Mr. Williams. Now, I will say, this should all be disclosed anyway. But I think Kenneth Copeland, I think Lil Woody, while he was on the stand, he told this. He got this out. While he was testifying on the stand in front of the jury, he explained, I tell them a little bit of the truth. And that's when he has that interaction with the court reporter about the color of the shoes. All right, her shoes are white. So I'm going to say they're white because I'm telling a little bit of truth. It's like the spoonful of sugar that they'll digest the rest of what they want to hear. And then I can get out of there. They'll think they got everything they want from me and I can go home. Like he does tell that to the jury in his own way. It's him that takes the initiative to do that. So that doesn't mean that just because we find that out in front of the jury, the prosecution should have still disclosed this to the defense. The judge should have made sure the defense had the right to be present during this ex parte, what are we calling it now? Ex parte party summit, the ex parte summit. They should have been present, right? They should have had the opportunity. So Kenneth Copeland getting up there and explaining it himself on his own doesn't make that not a problem. But I think it's great that Kenneth Copeland told the jury exactly that, because otherwise we may have never heard that publicly. Judge Glanville advocates for the District Attorney's Office of Fulton County when he tells Mr. Copeland just tell the truth, while lawyer Hylton is telling Mr. Copeland just tell the truth and let lawyer Hylton worry about impeachment and Mr. Copeland will not get in trouble. This excuses Mr. Copeland from giving false statements to law enforcement officers with the statute of limitations tolling provision. However, Judge Glanville tells Mr. Copeland to not worry about criminal violations, as the commission of same would not get Mr. Copeland into trouble. Seemingly, I underestimated the length of this affidavit. Seemingly, Judge Glanville, lawyer Love, and Mr. Copeland spoke off the record as Judge Glanville recounts that, as Miss Love said this morning, remember, Miss Love said if you overtly lie about something, like if you tell bold-faced whopper, then they can indict you on that particular charge. I mean, that particular false statement. Thus, Judge Glanville and lawyer Love will be called as witnesses and cross-examined by affiant as to what was discussed off the record. Judge Glanville is a necessary witness in this case, as is Hylton and Love, and hence, Judge Glanville must be recused, removed, and disqualified from his high position of judge, as he has voluntarily, knowingly, and intelligently forfeited the same. Judge Glanville also sanctions a lie that is not a bold-faced whopper, and is allowing Mr. Copeland then to seemingly lie about something that is not a bold-faced whopper. This is improper, and we saw them sprinkle this phrase, right? And that's important, right? When you're reading something, it's a long document. When you have something to anchor yourself to, like a phrase, like a bold-faced whopper, you can visualize how serious and significant of a lie, what that symbolizes. And we've seen them mention this in the actual motion, and now it's 3 or 4 times in the affidavit. They're anchoring to this phrase. Mr. Copeland states indirectly that if he confesses while testifying to murder, there is no statute of limitations for murder, and he will be prosecuted, and lawyer Hylton stated that he will not be charged. Glanville sits mute during this exchange. This Brady Giglio evidence never made its way to affiant by Judge Glanville or lawyer Hylton or anyone else at the Fulton County District Attorney's Office. This again is unforgivable. Moreover, when Mr. Copeland is speaking about murder, lawyer Hylton states that if she knows Mr. Copeland is lying, to wit, knowingly lying on a material matter under oath in a judicial proceeding, perjury, that Mr. Copeland would not be prosecuted for false statements. Again, this is Brady Giglio evidence that Judge Glanville and lawyer Hylton failed to reveal. Judge Glanville is no longer acting as a person on the judiciary, but is acting along with lawyer Hylton and Love in an impermissible manner. Mr. Copeland told lawyer Hylton that she knew Mr. Copeland would plead the Fifth Amendment prior to taking the witness stand. Lawyer Hylton denied the same. Judge Glanville was silent. This is also Brady evidence and impeachment evidence. This makes lawyer Hylton and Judge Glanville witnesses. Judge Glanville assured Mr. Copeland that he will not get in trouble for testifying, and his testimony would then be impeached. Why would Judge Glanville say this? This could be a false statement. This could be perjured testimony. Yet, Judge Glanville is promising witness Copeland that he would not get in trouble. This is not conduct becoming of a judge in the great state of Georgia. And again, the reason for that is the judge shouldn't be playing referee on what's true or not. But also you see in that transcript multiple times, Hylton, she infers, we want you to tell the truth, but even though we can't get you, you can you can confess to literally anything. Just don't commit perjury, just don't give a false statement. But Hylton is kind of playing ringleader about what she considers her own perspective, subjectively, about what testimony would be false versus what would be true. So Hylton's making the determination that if it helps us, we're going to look at it as truthful and we'll let you testify to it. If it's not helpful, we're going to make the determination that it's perjury and we'll charge you for that, but only that. Because we want you to tell the truth, but we want you to tell our truth. That was really, if you look through the second half of that transcript, that was the impression I got from Hylton's wording. So while she is literally saying the words, we want you to tell the truth and we don't want you to give false statements, there's a between the lines there. And it's problematic, and they're calling it out here. Judge Glanville ruled in his star chamber that if the state wanted to impeach Mr. Copeland, the state can do the same, and Mr. Copeland would not get in trouble for that, Why is Judge Glanville explaining and anticipating rulings on what may happen in court? Judge Glanville must be removed and disqualified. Lawyer Hylton explained that even if Mr. Copeland commits perjury, it would be treated as an inconsistent statement. This is again Brady Giglio evidence not revealed to undersigned counsel. And this is also important because they tried to use impeachment by inconsistent statement as an excuse to lay foundation or find another reason if foundation couldn't be laid for these police interviews. They wanted to find an exception to get these videos admitted. And they first tried through impeachment by inconsistent statement, and then they had to try the impeachment by contradiction argument. So again, this goes back to what was the roadmap? What was the roadmap for Hylton and Love in making sure they had the assurance they needed that Woody would testify and that they could lay foundation for these videos they need for future witnesses. Judge Glanville sat silent as lawyer Hylton told Mr. Copeland that he has spent enough time in prison for YSL. This is an extrajudicial information to Judge Glanville that marks YSL as a criminal street gang, a material element of counts in the indictment, including count 1, RICO. This statement marks that persons supposedly associated with YSL are guilty of criminality. This entire illegal and unethical ex parte conversation was during a critical stage of the proceedings for which Mr. Williams, as well as his counsel, had the right to be present for. This Star Chamber meeting also violated Mr. Williams' right to be present, as well as his right, and we get the same list again: right to counsel, effective assistance of counsel, right to present a defense, right to due process, right to a fair trial, right to a fair tribunal, and statutory right to a fair and ethical prosecution. All of these rights have been denied based upon the improper conduct of lawyer Love, Hylton, and Glanville, all working together on the prosecution team. Lawyer Hylton explained to Mr. Copeland that no one here expects Mr. Copeland to remember every detail from 2015. Why is lawyer Hylton able to speak for Judge Glanville, who was present but silent? It is because they are one team. Judge Glanville has denied Mr. Williams of a fair trial and violated his constitutional rights. Hylton and Judge Glanville functioned as one cohesive engine, as shown clearly by the following. Mr. Copeland asked, "You can't give me house arrest?" Lawyer Hylton answers, "No, you can go home by taking the stand and testifying. That's what you," and it's cut off. And Judge Glanville then states, "and come back tomorrow." Because again, that was Monday morning. Judge Glanville allows lawyer Hylton to be the judge by telling Mr. Copeland that he cannot have time to think about whether he's going to testify or not testify, and that he cannot be sentenced to house arrest but will remain in jail. This colloquy illustrates the fact that lawyer Hylton, lawyer Love, and Judge Glanville are working together as one. Judge Glanville has forfeited the right to be judge on Mr. Williams' case as he's biased. In fact, a fair judge does not have to keep a person who refuses to testify in jail. There are other punishments besides same, including a fine, house arrest, or whatever else the judge deems appropriate. What legal right did lawyer Hylton have to pronounce punishment upon Mr. Copeland? Now remember, over that weekend, Woody wanted to be with his family. He had a birthday and he also had a dog about to give birth to puppies. They didn't want to let him just have house arrest as one option. They acted like that wasn't even an option on the table. Judge Glanville fights for the prosecution by stressing to Mr. Copeland, they want your testimony. That is all they want, whatever that may be. Judge Glanville is an advocate for the state. Why does Glanville tell a witness that the state wants his testimony and that's all they want? Why does Judge Glanville care that the state wants a witness testimony? That is not the concern of an unbiased judge. And again, all that conversation about what they want and no mention of Woody's safety. So what was privileged about this meeting? Lawyer Hylton explained that Mr. Copeland will not be charged with perjury. Although that is outside of the order of use immunity that was provided by Affiant to Glanville, no Brady Giglio evidence was provided by Glanville or Hylton. This is legally wrong. Lawyer Hylton and Judge Glanville misstate the law of perjury and give promises of no prosecution. Again, Giglio-Bradio issue. And they don't disclose this to any of the defendants. And remember, I think on June 10th and 11th and maybe through that Wednesday, you see the other defense attorneys pop up and they're like, quite frankly, we're still in the dark about a lot of this because Steele and Shart were at least CC'd on the emails from Melnick. But the other defense attorneys knew even less than they did. They're like, we're still in the dark. That's how absent these proper disclosures were. Like, It's a mess. Judge Glanville and lawyer Hylton are necessary witnesses as Copeland confessed to them, I did these crimes, I'm telling you that. Coupled with earlier statements by Mr. Copeland about murder, which does not have a statute of limitations, Mr. Copeland is telegraphing that he is responsible for the indicted offenses. This critical exculpatory evidence was not given to affiant by lawyer Hylton, Love, or Glanville. In fact, the same was hidden. Affiant will call Judge Glanville, lawyer Hylton, and Love as witnesses because the jury needs to see how they cajoled perjured testimony from Mr. Copeland, hid Brady Giglio evidence, and worked together to wrongly convict Mr. Williams. The instruction that the judge had no interest in this case is not true. Mr. Williams will invoke his constitutional right to present a defense and call all necessary witnesses, including these 3 cohorts. Glanville must be recused. In a separate motion, lawyer Hylton and lawyer Love must be disqualified from continuing on this case for their misconduct. Glanville's a necessary witness because he handed an unknown document to Mr. Copeland's attorney in Mr. Copeland's presence. Affiant will cross-examine Judge Glanville regarding why he would give this unknown document for Mr. Copeland. The jury needs to hear from Judge Glanville so that they can determine whether Mr. Williams has been given a fair trial by a detached, impartial jurist. And I believe at least one of these documents, if there was more than one of them was a copy of the immunity agreement, because it was the first time Kayla got to see it. She's supposed to be prepared to represent and be there for Copeland, but they're like, here, we're going to drop this information on you right now. Like, lawyer Hylton will be called as a necessary witness because she, like lawyer Love, met with attorney Bumpus and or Mr. Copeland for an unknown amount of time off the record. Affiant will examine lawyer Hylton on the promises she made Mr. Copeland and other witnesses in the past, other witnesses as well, that are not revealed to Affiant. Judge Glanville and lawyer Hylton, working together, attempted to have Mr. Copeland dress in civilian clothing. Guys, this was like the part that burned me. And I'm going to cover another Supreme Court decision from a Texas Supreme Court about the importance, the constitutional right for a defendant, to have certain clothing, to not appear in shackles in front of a jury unless there's a real reason for it. So when you flip the script here and you have a witness that the state wants to come off as credible to the jury, when you flip the role and the importance of the visuals of someone's presentation, this part of the transcript burned me. I'm going to do, it's a short decision. It's 13 pages. I'll do a standalone video on demand on it. But this really stood out to me. Woody wanted to go out there in his clothes. He was sitting in this ex parte meeting in his jail clothes, handcuffed. And he's like, well, just put me out there like this. Why do I need other clothes? But Glanville and Hylton, working together, attempted to have Copeland dress in civilian clothing, so that way they could appear before the jury in a more presentable manner. Why would Glanville care how the state's witness, Mr. Copeland, appeared before the jury? This is specifically true since Judge Glanville did not do the same with an earlier witness, specifically Mr. White, who testified in jail clothing. Judge Glanville and lawyer Hylton speak for each other. Hylton answered Mr. Copeland's question on whether he would get locked up for this, and lawyer Hylton responded in front of Judge Glanville, so long as you testify, we will get an order to get you released. Judge Glanville remained dutifully silent as lawyer Hylton explained that we, would obtain an order to have Mr. Copeland released. Judge Glanville, lawyer Hylton, and lawyer Love are one and inseparable. They're like a throuple, as they violate all the named constitutional rights of Mr. Williams and their respective oaths of office. And yeah, great question. So again, I'm not ignoring the chat, but I am catching this randomly. I want to know why the body cams were turned off. And it'd be one thing if they just weren't on. But if they're explicitly told to turn them off, what's the excuse? And then also shout out to Corpus Juris Civilis for the 99-cent super sticker. Hey, Infamous Sylvia, good to see you. Thank you for sending the super sticker. And then Red Bunny, you guys are dropping the stickers today. Red Bunny, you're in the chat a lot with a lot of great insights on this case as well. So Infamous Sylvia has a channel. I'm sure if she hasn't talked about this already, she will. So make sure you subscribe over to Infamous Sylvia. And then Red Bunny, I don't think you have a channel, but I appreciate when I see you in any chat talking about this case because you have such a depth of knowledge of the little details of everything from day one and even pre-trial. So thank you so much for the support, you guys. And then let's see. Where was I? 59. Again, Judge Glanville and lawyer Hylton handed attorney Bumpus documents, who then gave to Mr. Copeland unknown documents. An affiant will again examine lawyer Hylton and Glanville on the witness stand. So there's like 6 or 7 different things now that they've said we want to put them on the stand as witnesses and ask them about these things. And Flesh of the Gods, shout out, you have a channel as well. Julie Horn has sent me videos. I forget which one it was. It was involving Kayla though, before the transcript came out. And it was great. You were jam-packed with different context in that video that I saw too. So shout out to Julie Horn if you recognize the name. She's the one that recommended you. And thanks for this detail here. The Bumpus also said she thought she saw an audio recorder. So great context there too. But yeah, I totally want to know about these body cams. So the jury has the right to know. They want to get them up there as witnesses. These are not the only times that Judge Glanville has shown bias against Mr. Williams. Glanville initially refused to release the transcript of this ex parte hearing that occurred because he claimed it was privileged. And now this is what I'm waiting for in the response, guys. In the response that we get, they're going to try to make this argument that it was privileged, and here's why. And can you play devil's advocate? Do you guys have just put the hat on? You're the state, you're Judge Glanville. What would you use to argue that it was okay to have this meeting? What would you argue? And I don't need you to actually, think it's credible, but what would you argue if you were in that position? And then shout out to, I see some gifts in the chat. So shout out to MMCS gifting 5 memberships. Make sure you say thank you if you got one. I love gifts. It's like my favorite feature on YouTube. And then we need another Dear Cat transcript read aloud. Heck yeah, I love doing transcript readings. So thank you so much, Dear Woke Christian and Ann Stuff using their member chat. Hit that like button. And Ann Stuff, also another great information that you bring forward to the chat conversation. So again, I appreciate all you guys in the chat. It's too fast for me, and I've got a course to teach in a couple minutes. I got to get off for once we're done with this. But we really do need to do a live stream, a conversation, a chat. Maybe we can open up the panel, and that'd be really fun. I like to keep these document readings constrained to the document, but there's so much to talk about, right? We can go on rants and rants. And then Glanville doesn't want to release the transcript because it's privileged, and obviously that statement is ridiculous. Additionally, Judge Glanville must be recused automatically since he defended his position against Mr. Williams' motion to recuse. So they cite this YouTube, and that was July 1st. That was that day where it was pretty much him talking. This honorable court, Judge Krause, must also be recused as she sits on the Fulton County Superior Court bench alongside Judge Glanville and has accepted re-election campaign money from Judge Glanville, specifically receiving $2,000 in April 2024 from Judge Glanville. This occurred during Mr. Williams' current trial, which commenced on January 4th, 2023, and is ongoing. I swear that the above is true and accurate. So, big old signature here from Brian Steele on July 8th. And then a much neater signature here from Keith Adams. There we go. There we go. And there were other exhibits, you guys. I will update. If you guys didn't already grab the document, this is obviously the 56-page transcript. What else do we got in here? The contempt portion of the proceedings. So this was oral transcripts. If you watched it, this isn't anything new. They just needed to make the record, they need to request the transcripts. So it wasn't anything that was private, but they need the transcripts for their argument. What else do we got? Yeah, and sorry again for the strobe light scrolling, because I know on the screen it's not fun to watch. And this is all the stuff when Gactyl showed up. And they were arguing with him about criminal versus civil contempt. All right, what do we have here? The notice of appeal. So we talked about that. That was when they wanted the superseded bond. This was filed by Colette. We've looked at all that stuff before. But do we get the order of contempt? I did want to see the order of contempt. It shouldn't be long. I thought it might have some interesting stuff. And they attached this whole motion to discuse. We have read through that in a separate video. And these are all the exhibits they attached to that motion. Okay, so the order of contempt. Okay, I think we did read this. We read this because it was attached as an exhibit. So I think we're caught up. And this was the initial affidavit, right? Yeah, sweet. So that was the initial affidavit. So these exhibits I think we're caught up on. Really those emails, seeing those emails was important. Those emails from, let's see, those emails from Melnick. Melnick says bold and loud. My client is going to plead the fifth. There's no denying it. It's bold, loud, and clear in that email. And then shout out to Janelle. So Janelle Barry Tucker sends a $10 super chat. Thank you. It says, thanks, Kat, for your diligent reporting. The energy and insight you bring to this case keeps me glued to YouTube like it's a masterpiece mystery. I love it. Well, thank you so much. I really like being on this side of it because usually I'm on YouTube to watch other creators. But this case has had so much action in it. I really like to look at attorneys sparring with each other, and there's been a ton of that in this trial. And then I really like to look at instances, not usually judicial misconduct. I usually like to look at instances of prosecutorial misconduct. And here, since the judge is just making himself part of the prosecution team, that's all one and the same here. So definitely love to talk about it and love to have you guys in here as well. So thank you for your $10 super chat. And again, super apologies. I'm not always used to having a chat that I can't look over and keep up with. And then I think, is this the document that you shared, Drea? The filing? So Drea, I think, just shared the full PDF, all 233 pages there. So if you want to read through it on your own time, shout out to Drea. Drea's a great mod, and it was really nice of her to share the document link here too. So super, super nice. And then also, thank you, Esquire 1995, for the $2 super chat. Excellent coverage. Well, I'm glad you're in the chat. And let's see. Okay, so Miss Sylvia did do a video on this already. Okay. Yeah, so I was making an assumption that if she didn't, then she would. But yeah. And then let's see. Heck yeah. So K32, all I gotta say is Glanville's biased based on all the times he says bring it up on appeal. Yep. And again, this is just one motion for recusal, and you see it's already 233 pages. The argument itself was only like 30. When you think of the appeal, you have to attach all the relevant transcripts. So think how long the full appeal packet will be. Like tons and tons and tons of transcripts will need to be attached, any relevant exhibits. I mean, like we're already 100 days in. If it's paused here, I mean, it could reach 1,000 pages for one defense attorney's appeal volume packet. It would probably be way more than that because of the transcripts alone, thousands and thousands of pages. Like, just think about that. And then Anna P. in 1999 says, what happens now considering the prosecution was adamant in open court that they did not know he was going to plead the fifth? All of Fulton County reeks of corruption. And that's huge. And again, bringing all of Fulton County into the equation because Fani Willis had to sign off on that immunity deal. You've got a lot of other attorneys. We have Ashley Merchant, that's a big name. But you've got a lot of other attorneys that are already trying to chip away at things that don't seem to smell right in Fulton County. So when you hear about stuff like this, you see a Chief Deputy District Attorney Adrian Love and then ADA Hylton, and then the judge saying, look, we don't know. We didn't know he was going to do this. And it's clear that they knew. That's just fodder. That's fodder for people to put the lens further onto Fulton County as a whole. And so thank you for your super chat there. Guys, again, I'm not trying to boot on out of here, but I have a course to teach at exactly 1 p.m. Eastern, which is 1 minute away. So I'm going to be late to my own course. And we have another super chat. So thanks, Lot B. I appreciate that. No question or comment, just pure support. That is so nice of you. And then let's round it up there. You guys, we will plan something. I do believe Kayla Bumpus is going live today. I think she's speaking with Judge Peterson, former Judge Peterson. So there's that for you guys on the calendar tonight if you're looking for something to tune into. I would love to have Kayla come up and we'll get together and talk about her reaction to this motion if she's willing to do that. So I'll text her. I'll see what's going on if she wants to do something together when I have some more time. Thank you guys all for tuning into this reading and sharing all your thoughts along the way. I'll catch you on the flip side next time. You guys take care.